Honorable Supreme Court disposed of the matter, saying that you make a request before the Honorable High Court for early listing. I'm requesting for early listing, my lord, on Monday. It covers all the.
So without this thing, counter of Mr. Rao and the government, you want decision on Monday? When, where is the order passed by Honorable Supreme Court? Against which order you went to Supreme Court?
My lord, order was not available, my lord. Citing urgency in the matter.
No. Against which order of this court you went to Supreme Court?
My lord, admitting that matter, my lord, there was no order as such, my lord.
Against no order, SLP can be filed. Or you can file a writ petition under article. What is this?
Medical admissions matter.
All these persons are anxiously wait. Don't waste time, if I may say so. So which is the order against which
it was simply disposed of, asking the petitioners to make a request, my lord.
Against which order you went to Supreme Court by filing SLP? Please tell us.
There was no order as such, my lord.
Then without any order, SLP can be filed. He should say, we have not rejected the prayer. Not possible. 22nd August. Be ready, Mr.
Yes,
which order, which IA,
yes.
which Supreme Court?
Yes.
Tell us.
Very.
21st is already 76, maybe 90 cases. So we'll
22nd.
22nd August.
Obliged.
May I have your lordship's leave to make a request? Lord, items 41 to 44 are not part of the batch, my lord. I wanted to bring to your lordship's notice.
41 to?
An amendment, my lord, to the rules is challenged for the NCC quota.
Yes,
State
Mr.
government
Rao.
counter is not filed.
Mr. Rao.
Kindly say, my lord, he obtained interim order, we file an application to vacate.
Not in this case. Not in, no, it's not there.
There
Not
is
in
no
this
interim
case.
order
No.
in your favor.
Order is to accept my application. There is no vacate petition. Ready though to argue, my lord. I am ready to argue, but my friend says it is connected with the batch. Well, it's not right. Well, that's what I wanted to bring to your lordship. Separate matter altogether. That's 100% reservation. My lord.
What do you think that we will not even reach item number?
No, my lord. Since my lords have said the entire batch will be taken by 2:30, I wanted to bring to your lordship.
No.
If it is called seriatim, I'm sorry.
Every time we have to, the advocate, Mr. Rao and Advocate General said that he said that this is different than item number 85
He
and
said they are all together. That's why, my lord, I had to make that request.
together, Mr. Rao.
No, lordship, 84 to 87 are different, my lord, this batch is different.
Very well.
Yes.
Please, your
But this contempt appeal is filed. I'm appealing.
Yes.
It's- Contempt appeal is filed against the orders of the Honorable Single Judge dated 21/4/2023. Clad.
What is the ground? There is no dispute that you have not complied with the direction. The only thing is that under order 38 rule 5, the court could not have passed the order.
Yes, that the suit is filed, my lord, for recovery of money of rupees 1,75,000. In trial court application is filed.
19 volume 4, I asked them people research. Rahul and company, not kept. That's the only point. 38.5 could not have passed.
Yes, blood. And 38.6 says, blood, the remedy. If the failure to comply the order, rule 38.6, blood, your lords may kindly see. Order 38, rule 6. CPC, blood.
Yes, 38. Oh, 38 is a
Order
provision very
38.
often. Yesterday also we went through 38. Not attachment.
May I read, my lord? Order 38 rule 6. Where the defendant failed to show cause why he should not furnish security or fails to furnish the security required within the time fixed by the court may order that the property specified or such portion thereof as appears sufficient to satisfy any decree which may be passed in a suit be attached.
So therefore, the court could have passed an order of attachment.
Yes, ma'am.
Where is the order directing you to, in addition, right? An action may give rise to a civil wrong, criminal wrong. Like
Page 8,
see,
you lost my kindly see the impugned order.
one particular, what we are trying to test it on principles.
Yes.
One action of any person, individual can give rise to civil as well as criminal consequences.
Yes.
You agree? So it does not say that no other this thing except order 38 rule 6 can be taken against the person.
11A also comes into picture, my lord. Order 38 11A for execution proceedings. But where the Honorable Supreme Court held that where alternative remedies are available for execution, then the court cannot.
There is that case law.
Yes, but I just passed on the judgment.
After a long time, I have come across this.
All-
I will tell you this thing.
This is first citation is Milad 2004 SCC 400. Relevant page at 4 Milad. Relevant.
Yes.
RS 7 Milad. Relevant page 4 RS 7 Milad. We may reiterate that the weapon of contempt is not to be used in abundance or misused. Normally, it cannot be used
No,
for.
no, we were discussing that I, as an advocate, exactly succeeded on this very proposition of law. Before we may tell the name of the judge also, Honorable Mr. Justice D.M. Dharmadhikari, who former judge of Supreme Court of India and Chief Justice of Gujarat High Court. This very proposition, so I immediately recollected. Read that relevant thing.
We may reiterate.
If there is a remedy, no contempt.
Yes, Milad.
Where is that?
Milad,
Read that line.
RS 7 Milad. We may reiterate that the weapon of contempt is not to be used in abundance or misused. Normally, it cannot be used for execution of a decree or implementation of an order for which alternative remedy in law is provided for. Discretion is given to the court to be exercised
Fine.
for maintenance of the court's dignity and majesty of law. Further, an aggrieved party has no right to.
All right, all right. This appeal under section 19 of Contempt of Courts Act 1971 has been filed up against order dated 21st April 2023 passed by OS is
Petitioner is the plaintiff in the suit.
which pending since when?
2018. Now,
What is the stage of OS?
the suit is not, written statement is filed, but kept quiet. No trial is taking place.
Oh, no trial.
Considered not suit, not.
You will cooperate and will not seek any unnecessary
Yes,
adjournment subject to that.
Ready to proceed with the trial shot.
Ah. All right, then we allow this appeal.
Yes, not directed the suit itself, not.
Ah. Time bound manner, right? 18 to 5 minutes. So we will direct the court to proceed expeditiously and record his undertaking in support of opposite submission so and so
So far as deposit is
As-
concerned,
placed.
deposit is concerned.
Deposit.
Pending suit, my lord.
Ah.
It is a 50 lakhs building, my lord. We sought for the recovery of money of 1,75,000. He said it is 50 lakhs worth building. There is no question of escaping. But it is only a deposit of, my lord, are giving the security in the court.
No, this is an appeal against order of his conviction under section 19. We are not deciding your grievance in appeal. See, Mr. We are testing the valid. Please understand. We thought that you are agreeing for disposal of the appeal itself.
Yes.
No. You want to file reply? File reply. We will decide.
Yes, my lord, we will file reply. I will file my reply. I'll file my reply in 1 week.
No,
I'll-
but no, this it can't be. Everything can't be done in 1 week, right?
No,
What happens to Mr. Rao and his clients who are awaiting, whose results are not being declared? And why this man should go to jail out of turn? He will go whenever he goes. That's why we were dictating an order. You intervened. We thought that appeal itself
why,
can be
why
disposed
are
of.
submitting, my lord, instead of going, my lord, instead of sentence, my lord, you will ask me set aside. Sentence, my lord, only to the extent of depositing the amount as a security, my lord, in the trial court and maybe dispose of suit.
There is already an order. There is already an order of this thing. There is a remedy to you. You did not get it. Take recourse to order 38, rule 6, order 38. Then Mr. What we have
Okay.
stopped
Yes.
advising people on this thing long back. It's your choice. Learned Counsel for Respondent Press may file counter to IA so and so within 2 weeks. In the meanwhile, operation. So in addition to this IA so and so before submit IA 1 or 14 sufficient cause condonation of delay is pro forma thing 48 days allowed. Therefore delay is condoned, IA is allowed.
Oblige.
May please. This matter I request for Wednesday, Milord, senior counsel, I engaged Milord is not there.
Your lordships, in this matter, I am appearing for respondents. In this matter, I filed my caveat, your lordships. In spite of filing my caveat, they did not serve.
Learned
copy.
Counsel for the petitioner undertakes to supply copy of petition along with annexures to write her name who has entered appearance on caveat.
It may be posted on Friday, your lordships.
Why?
Senior is out of station.
No.
That is a reason.
Senior counsel doesn't mean that today you are only saying particular date. Tomorrow you will say 2:30,
No, your lordships, on
at
Thursday or Friday.
10:30, Friday evening 8:30. This we can't do. Sorry. Senior is available to argue the case. If he is not available, we will decide the case.
At least on.
Because we have taken oath to do justice, right?
Deeply obliged.
Fine. Don't tell. No senior counsel has privilege like this. That Saturday at 10 a.m. in the morning, nothing. You argue, better
Yes.
you argue. There is nothing for senior
Yes.
to argue.
Yes.
It's a CRP.
Yes.
3, 4, 6, 7. Yesterday's order.
Yesterday's order, Milord.
Same. These people have been admitted.
Yes, yes.
Yes, madam.
Yes,
This
sir.
order.
This matter,
Three.
Milord. Item 3,
1 minute. Item 3.
item
you note
3,
down.
6 and 7.
Ah,
Milord,
3.
they go along with The order passed in writ appeal number 815.
814 or 815?
814 is for item 4.
1 minute. Item number 3 goes with WA 815.
815.
So madam, WA 815, same order we have passed yesterday,
3,
that
6,
very order.
3, 6 and 7.
3, 6 and 7.
Yes.
Huh? Same order as passed in WA 815 of 23 yesterday, 18/8/23, same order. Then
Item 4 minute goes
Ah.
with writ appeal number 814.
this is the order 814.
May I make one request, Madam? If possible, minute, some early date may be fixed, Madam. So
You
that,
will have to move an application, right?
very well.
Yes, we'll consider it.
Item 5, G. Vatsudhan Reddy and Shrikant GP for revenue.
Item 8,
Please, your lordship. My lordship,
6 and 7 done, right?
that the present appeal is preferred, my lord, against the order passed by the single judge, my lord, in page number 15. The lordship, the order is passed, my lord, without giving an opportunity. Your lordship, page number 15 is the impugned order, my lord. Your lordship, page number 16, my lord, I may permitted, my lord, this order is passed, my lord, without giving any opportunity. My lord,
Not heard.
not heard. This is a admission matter, my lord. My submission is that, my lord,
You can, they will give you a notice for survey.
my submission is that, my lord. Once
You
the,
participate, right?
I part not participated.
No, you
Your lordship-
participate now.
Participate now in
One
the survey.
submission, my lord. Your lordship, may relief claimed by the one relief claimed by the respondents, my lord, not to conduct of their survey of their lands. I have no objection for not to conduct any survey. But they grievance, see the my lord, prayer relief. The order is passed beyond the scope of the relief claimed by the respondents 1 to
Oh, where is the
page
relief?
number 13, your lordship, 32. The
32.
relief claimed by the respondents 1 to
1,
13, 32, my lord.
32.
Declaring the action, I'm sorry, declaring the action of the respondent 2 and 3 in taking up the survey of the lands in survey number 320.
1 minute, 1.
Your lordship, page number 32, my lord.
Mandamus.
They're asking to not to conduct of the survey of their lands. I have no objection, my lord, to granting of that relief. Your lordship, see the page number 15, my lord. The relief is
No,
the,
this is what is happens when the lawyers don't draft and leave it to the
let the order is
one
that
who this thing types.
one submission, your lordship may clarify the order, my lord, let them conduct of the my survey number 341. They are claiming other survey numbers. In fact, my lord, they purchased through, they are the plot owners,
You have, no, your survey number is,
341.
and this is not the survey number.
Yes, my lord, they are claiming different survey numbers.
Can we clarify? Is this survey number 314? These are other surveys. He also approached the
Then I have no objection for allowing the petition because they
No,
are.
that's fine.
Yes.
But see, Mr. One of your this survey number 341 is adjacent to through 340
Yes.
KA, etc.
That is true.
Is maybe grievance that either he or you have encroached.
For that reason, your
So
lordship,
therefore,
they are claiming.
you are this thing, Mr. If a survey is conducted under the rules, we have dealt with it. Notice to affected parties need be given.
But
Nobody is given any title in
that I,
the.
Milord, that I
You will
clarified.
also be noticed.
Yes, Milord, that I clarified that Milord, they purchased, they are the plot owners.
No, no.
The
So
vendor
what-
name is.
just a minute. What we will clarify is that while conducting survey of these numbers,
Yes.
the petitioner who is a owner of adjacent survey, appellant who is owner of adjacent survey number 341, notice will also be given to him.
My, your lordship, my submission. They are asking for not to survey the lands.
That the stenographer has typed right and he has not read. You are petitioner.
I'm for the respondent number 1, your lordship. Who is the petitioner in the?
Petitioner.
Milord,
It's obviously a mistake, right?
no notice has been issued, Milord. The vendor name is Ram, Milord Vijay Bhaskar Reddy's name reflecting Dharani portal. Notice has been issued to the vendor, Milord. It is unfortunate case, Milord. The plots are.
Nothing, no unfortunate.
Milord, the agricultural
A
land.
fortunate case where you are representing appellants
Yeah.
on a working Saturday, it's a fortunate case.
The agriculture lands.
We have the benefit of your submission. Don't say
I
unfortunate.
have one submission. The agricultural lands converted in the year 2003. Plots, they purchased the plots. The vendor name Vijay Bhaskar Reddy, whose name is reflecting Dharani portal as on today, receiving the benefits. That notice has been issued to Vijay Bhaskar Reddy. I filed the document. Page number 56, your
Notice
lordship.
of this appeal has not been issued, right?
Page number 56, my lord.
Notice of this appeal has not been issued, right?
Your lordship, may
Heard on the
let the
question.
notice to the affected parties conduct survey. I have no objection. Let them raise their objections. I filed
No,
my
no,
objections.
That's why we are issuing notice to respondents, right? Petitioners, he is not appearing for petitioners. How he is appearing, we don't know.
No, he is
Your
appearing for-
petitioner,
1 to 13, my lord. He filed the writ petition, my lord.
petitioner, he said, I'm for
I'm for the
respondent.
respondent number 1 in the writ appeal, your lordship. In the writ petition, I'm for the petitioner. in the-
So what relief, Mr. Reed, what?
Sorry.
Page 32, what is the relief claimed in the petition?
Your lordship.
You
No
told
notice
us, we wanted to ask you this question. You told us that I am appearing for respondent. You should have said I am appearing for read petitioner. Read page 32.
For the reasons stated above in the accompanying affidavit, it is hereby prayed that this honorable court may be pleased to issue a writ, order or direction, or more particularly one in the nature of writ of mandamus, declaring the action of respondent number 2 and 3 in taking of the survey of lands in survey number 320 by KA, 343 by KA, 344 by 1, 342 by KA 7, 342 by KA by 5, and so, situated at Jammi Chedu village, Gadwal Mandal, Jogalgumba, Gadwal district, as being contrary to the guidelines and instructions of this honorable court in writ petition number 8413 of 2023.
No, Mr. If a survey is being conducted contrary to the guideline, read petition is not the forum. Merely because land is priced at 100 crore per acre, that does not give you constitutional right to file a writ petition. If survey is being conducted, we are sure that there is some authority before High Court which examines. What is it, Mr. You don't say anything. What is the authority? Supposing if a person is aggrieved by a survey, he has a right of appeal, right?
Lordship,
Which act?
Lordship, one submission, your lordship.
Yeah. Survey and then you should tell us, right? All disputes are this entertain nothing.
Lordship, my senior counsel.
File enough, nothing, no senior counsel.
Sir,
Yes.
Lordship, my senior counsel's mother is hospitalized, your lordship. Your lordship may post this matter on
No,
Wednesday.
then why were you not then said that I?
Sir, Lordship,
No, this file an appeal, Mr. There is no
Lordship-
senior counsel for survey. We are designated senior counsel for survey
Lordship,
and
no,
filing an appeal.
with regard to our land, your lordship, there was no notice issued to us, your lordship, in this matter.
So therefore an appeal under section 9.
We have already made submissions before the revenue, before the authorities,
The
your lordship.
prayer is that they should be restrained from carrying out. You did not. Just a minute, Mister. You did that means you didn't understand and you have not read the order passed by learned single judge. His contention is in the petition you seek a declaration that the survey conducted by these people is contrary to law, right? So no notice given. The single judge allows your writ petition and says survey be conducted. This is the relief which you have not prayed for in the petition. That's what he's trying to submit. How can a relief which is not sought by you can be granted? Answer this question. No senior counsel required.
Lordship, my senior,
Nothing. No senior counsel is required. This is what it is.
Lordship, I am handicapped, Lordship.
Nothing. No handicapped.
Lordship,
Everybody is handicapped. Yes. Mark the presence. Mark the presence.
Lordship,
This intra-court, sorry. This intra-court appeal arises from an order dated 4th of August 2000. The lesson, anybody who wants an adjournment should say so in the beginning, not after you are thinking all along the appeal will be dismissed. Let's take a chance.
No,
Now it is not being dismissed, so you suddenly remembered senior.
I was giving respect
Not
to
fair.
the Your Lordship.
Nothing, not fair. This intra-court appeal is filed against an order dated 4th of August 2023, passed by a single judge, by which, no, not interim order.
Interim order. Interim order.
Hey, what, this is, we thought it's a final order.
No, Milord. Interim order.
You are a respondent.
Yes, Milord.
You file vacation.
No, Milord. The order is for beyond the scope of the relief claimed by the respondent. That
No,
my
no, no.
submission.
You are a respondent in the writ petition.
Yes, Milord.
Then file an application. We thought it's a final order.
It's not final.
You
order.
have you have the liberty to move an application for vacation of stay and argue exactly what you are arguing before us.
Lords may observe that and dispose of the.
Now senior counsel is not required.
Yes.
Saved Your Lordship.
Some time may
Not
be
fair
fixed
to
in
the
Milord.
court.
Your Lordship.
You should have said interim order.
Some time may be fixed in Milord.
1/9 it is posted. This intra-court appeal has been filed by respondent number 5 and 6 in WP number 21106/2023, passed by an ad interim order. This is not done.
One more.
If you would have said that I have filed an application, not taken up.
That's
then
not
it's
the
a
case, Milord. I'm not stating that, Milord. I not.
No,
Some
no.
time may be fixable, Lord. My submission is that, Milord, it is also violation of one. Some time may be fixable.
No, no, violation of natural justice. So we will remember, Mr. In your case, no ad interim order henceforth, because we will remind you where you will be petitioner or appellant before this court, no ex parte interim order, because it is violation of natural justice. We would have fixed a time limit, provided you would have said that, sir, in the month of April, I had filed an application seeking vacation of stay, and that is pending for about now 4 months.
Because of this order, survey, they are not stopped conducting my land. They're not their lands. That is my submission.
For to show bona fides, you should have this thing. Yes.
Applies.
You, Mister, did not even tell us that it's against an ad interim order, sir. He can file a vacating stay. You are telling us senior is out of station.
No, senior mother is hospitalized. Also. I'm just starting out, your lordship. I'm a newcomer, your lordship.
No. So how after disposal of the appeal, the smile has come back to your face despite your senior is away?
Because
Appeal has been disposed of.
yes.
Don't take chances. Don't do fence sitting, right? Let's see what the court is doing.
No.
Otherwise, you don't appear. If you ex parte fresh motion cases, do not appear before this court if you intend to take an adjournment. Because in your absence, maybe we hear him and dismiss it also. Or whatever. Even if an order is passed, you always have the opportunity to apply for vacation of stay.
Today is the lesson, your lordship.
That's good. Good. So Supreme Court also deprecates the conduct of fence sitting. They have said that fence sitters are not entitled to any relief under Article 226. Correct? Yes.
I'm obliged, your lordship.
Interim order. Heard on the question of admission. Appeal is admitted for hearing. Also heard on IA number 1 of 2023. Issue notice on behalf of
So Challagona, I'm on behalf of Challagona Region.
respondents. The respondent so and so is accepted by Mr. So and so learned counsel. Yes. Yes, you want to file objections to IA?
Countering the IA, but I am ready to argue the appeal itself whenever your lordship.
We have admitted the appeal, Mr. Everything.
Hearing the writ appeal, there's
No.
no question of a counter.
No counter. We are asking whether you want to file counter to IA.
IA, I'll file counter.
That's what we are saying. You know that what happens when we hear 2023 appeal, that your case 2004 pending, bunch you argued for 2 days.
This also is going on from 2018, my lord, just for a meter.
We have come, at least, I mean, we will try to jump from 2014 to 18. Do our best. But you understand, right?
My lord, this is
Counsel
only for a meter to be installed at my cost. That's all it is. The direction is to install a special energy meter at my cost.
All right.
You
File objections to this. Learned counsel for respondent praise granted 2 weeks time to enable him to file counter to I.
Lordships are posted today.
After 2 weeks.
Well, right.
No. Now, Mr. Chaudhary, we have announced that auto dating system is commencing from Tuesday. So don't worry that 2 weeks means it will not come up for 3 years. Not like that.
That's always been a fear in the court.
No.
2 weeks never comes.
No. It will come. There will be every this thing undated case will have a date given assigned by a system. Right? So that is
Not getting listed by.
No. Yes. So after 2 weeks, if it's not listed, you please tell us. We will test the system with how it gives. It may not be exactly 2 weeks means immediately, maybe little later, 2 days here and there, but it will come up.
But date will be shown in the.
It will be there shown in the system to you, which you will have access. You can find out what is my next date to this case from Tuesday onwards.
My lordship, with the kind permission, I'm appearing for the petitioner in this matter, Your Honor.
Local candidate. Mr. Rao.
He studied in Karnataka, MBBS in Karnataka. He studied his MBBS in Karnataka. He wants to be treated as a local candidate in state of Telangana. For preceding years, he did not study.
You file whatever.
My lordship, my submission, humble submission, your lordship. The writ petition is filed questioning the action of the respondent number 2 and 3.
No, that's fine. That's why we are asking Mr. Rao to file counter.
There is an urgency in this matter, your lordship. That phase 1 counseling is completed. Phase 1 admission is completed.
Whenever phase 2 counseling is notified, it's a pending here. We will granting time to file objections, counter. And if the phase 2 is notified, we always entertain out of list memos, you remember, right?
My humble submission. Only I will.
No, in anticipation of second round of counseling, we cannot grant admission to you today to which course? To MBBS course. PG course. PG course in dermatology.
My lordship, one submission, lordship.
Mr. Rao, correct? He wants admission today in MD dermatology on a concessional rate. You should give him a scholarship for having studied in Karnataka. This is the prayer. So what you are arguing about is entitlement. His case is today admission plus scholarship by the university, free of cost.
My lordship, one submission, lordship.
If you don't understand,
from Nagarkarnal district, Telangana state. Forefathers are a native of Telangana.
We are not.
He has only pursued his foreign degree.
You don't understand, Mr. We are not dismissing your petition. We are entertaining it. The prayer, he has to be heard before prayer for interim leave is granted. We are granting him time to respond by filing a counter in the sense that why we are granting time, because second round of counseling has not been notified.
Yes.
You yourself are saying. So should he not even get a time to file counter? And we should, that's why we are saying that grant me admission today in MD, this thing, which dermatology in Hyderabad, and give scholarship and sponsor free education.
My lordship,
this is the prayer.
Yes, my prayer is respondent to direct the respondent to and consider
And
the
we are
petitioner.
giving you liberty when, as and when second round of counseling is notified. You don't understand, Mr.
I do understand.
You don't understand. Yes, that's what it is. Nothing. We can't grant you admission even if you have 100% case without hearing him. Heard on the question of admission, petition is admitted for hearing. Notice on behalf of respondent so and so GP Medical Health and 2 and 3, Mr. Prabhakar. Sir, when second round of counseling is notified, you can always, we are telling you this. You are arguing that I am forefathers and here, no. This law.
No, you got yourself registered for A category. You are saying you forgot to register yourself for B and C category.
What can be done?
What can be done?
They prevented, anybody prevented?
Application that is not being open.
He can accommodate. He can accommodate any time. We don't ask us to do. Mr. Rao, Mr. Prabhakar Rao is a very influential and powerful person. He can say that we can accept your online application anytime and grant you admission in which you want MBBS course in Hyderabad. So he can grant it. Don't ask us to. At your level, you talk to him, he agrees, fine. We will dispose of the petition. But asking us to adjudicate, probably a bit difficult. You are not an illiterate person, right? Huh? Not that you did not understand. Fine.
Anything in my lord. They say that my lord that it is impossible. They wanted to vote on it. How they in various cases also there.
So Mr. Rao, in case, what is he there? He is attributing so many words and statements to you.
No.
This would be no prejudice cost.
No, prejudice, actually already merit list is prepared. But counseling is already commenced.
Registration got closed on 12/8.
Yes, Lord.
And then merit list is prepared when?
Prepared, Lord, the last week of July, Lord, and 6th, Lord, August.
No, 12/8, the registration closed.
Date.
The registration closed on 12/8, right? 12/8.
12/8 registration closed.
Registration.
That's the management quota.
When the registration closed?
12/8, Lord.
12/8. Thereafter, you have prepared the merit list.
But prepared, merit list is already prepared.
Merit.
But there is a GO, Lord, prohibited.
And is it issued, Mr. Rao?
Lorships.
Has it been issued merit list? No.
Merit list is not published, Lord. Merit list
It will be published when?
at the time of calling applications on to online web options.
So when it is likely? Likely?
2 weeks, it takes.
Huh?
2 weeks.
2 weeks.
After first phase of counseling, they will give a management quota counseling.
No prejudice.
Online application is allowed to be registered.
It is up to them. Mr. It is possible or not, we don't know. It is not in his hands now. It's not a manual thing that they will ask you. It's all this thing dealt with online, right? Physical form, you cannot even submit an application, correct?
Physical form is not there.
It's not that they are not.
No. Where they've done it? Which paragraph, which petitioner?
There are certain order copies that I have.
No.
But they have gone beyond it. They have.
No. This is not on account of any this thing inaction or delay on their part. You are opted to this thing for category A and did not opt for B and blame university for this.
My only interest is why did you do it, my lord?
No, why did you not do it? Tell us any explanation. Then we will ask Mr. Rao what to do.
That's evidence citing category A.
No, it's not a case of any this thing error in the system or not uploaded. I uploaded the documents, did not upload. He is not saying that he did not receive your application. In case of any the such thing, we would have asked him. But if this has occasioned on account of your inaction, what can be done?
Very true, my lord.
This is then the true is true. Truth remains truth, irrespective of what anybody says.
My lord, tomorrow if I switch out to category A, if I am eligible in category B and C, I will need to get something. So with that, I can't.
Mr. Rao, page 29, page 29.
Yes, Lord. He has to make a representation.
That he is not saying.
Will consider.
He is very magnanimous, right? Make a representation, approach. Otherwise, that's why we told you don't understand. In the beginning, don't ask us, ask him. We told all this to you. You should have said that, yes, sir, I will approach university. Please give me liberty. Why if we pass an order dismissing your petition, they can't do anything. Go and convince them. Yes, in this writ petition, mark the presence with consent of the parties heard.
Sir, I'm back to represent my
Well-
lord. 12 same my lord, in this matter, I'm already made the representation. Page 13.
So, madam, 12, same thing. You have also not indicated B and C.
Yes, madam.
So, learn it, then he submits that he, with regard to his grievance, you have submitted a representation on
On 15/8/23, madam.
15/8/23, which has not been decided by so and so, then same submission. And Mr. Rao submits that the representation shall be decided. So within 2 days from today, accordingly petition is disposed of. 12. In this case, 12, it is made. In that case, not made.
Apply.
Independence Day, huh? You made a representation on Independence Day, right? Huh?
But when they are not permitted to upload in the website, they are immediately.
Wanted a freedom from all this, huh? A category also, B and C.
Only management quota, madam.
Lighter vein, Mr. Yes.
May please.
Yes.
With regard to the present petitioners seeking a relief of opportunity, given opportunity to petitioner to deposit 15% of outstanding amount as directed by the Honorable Court in a previous writ petition filed by me. So.
Additional notice, right? Have you supplied a copy to the council for bank?
Milash,
Bank,
we already supplied.
where is it? In every, in property disputes, they stand, right? And this
No.
thing matters, they don't turn up.
Is a no standing counsel is there,
Huh?
Milash, with regard to the
Who is there?
On whom did you serve papers?
Milash,
Who is the counsel for Bank of Maharashtra?
there is no counsel, standing counsel is.
Then whom you served? You just now said I served the copy.
Milash,
Huh? Mr. We would appreciate that if you, this order was passed when?
yes, Milash.
No, this order was passed by when?
On 8/6/2022, Milash.
8/6/22.
2022, Milash. Yes, Milash.
8/6/22.
Then
Just 1 minute. 8/6/22. And by 8/6/22, you were granted 30 days time.
yes, Milash.
That expired on 8 July 22.
Yes, Milash.
After 1 year and 1 month,
Milash.
you are seeking extension, which is frivolous. Even you,
Milash,
if
meanwhile,
you would have deposited the amount, saying that I have deposited now and please time be extended bona fide. After 1 year and 1 month, no question. of
Milash,
exam.
meanwhile, I approached the DRT,
Frivolous.
Milash. I approached the DRT and the Secretariation Appeal filed by me. With regard to Milash, may kindly consider.
No, now the DRT is in a position to this thing decide. Nothing, no case for interference. Correct?
Milash, with regard to the extension of time and
When did
continuation
you
of the
file the
dealer-
appeal? When did you file the appeal? Appeal under section 17 before DRT.
Yes, Milash, just within 30 days, within 34 days. August, Milash, 2022, I filed this.
August 22. DRT appeal.
Yes, Milash.
Then why do you need protection from this court? This was over.
Milash,
Nothing.
the same was
No
already.
relief can be granted, Mr. You understand?
Milash, may kindly consider at page number 48, Milash. The DRT recently disposed my application and dismissed the same and rejected the same. On the ground of.
Appeal dismissed.
Yes, Milash, it's an interlocutory application. My application was not.
Hey, your appeal has been dismissed by DRT.
Interlocutory application. SA was not at numbered, Milaship. Milaship, may kindly consider.
No,
at
no,
page
you
number 48.
Either you are unable to hear us, so say so that, sir, I am unable to hear, or I did not get it. The question we are asking is whether your appeal has been decided. You say
My appeal was
interlocutory-
not yet numbered, Milaship, within
not
that,
yet numbered.
not yet numbered,
Then
and
we have
IA
to
was disposed.
Challenge that order rejecting your IA.
No,
Which IA has been rejected?
Yes, Milaship, only section 5, condonation of the delay, Milaship. I filed within 34 days of delay, I filed the said appeal.
Condonation of delay rejected when?
28/7/2023, Milaship.
28/7.
7.
Then that order is what remedy available to you against that order?
Milaship,
Under section 18, DR 80. This is all misconceived. We will impose cost for wasting the time of this.
Milaship may kindly consider.
Nothing.
Milaship may kindly consider only one aspect with regard to the same analogy adopted by the Honorable Supreme Court with regard to the limitation aspect. Section 48, section 5 is not applicable to the filing of the present DRT appeal matter.
Rely that Honorable Supreme Court in DR 80 when you challenge that order dated 28/7/23. This is not an order challenge the petition. You are seeking extension of time to deposit the amount. Where is the question of granting time to extend the time to deposit when your application
DRT observed that I have not filed the said application before the Honorable Court within time. But I approached the Honorable High Court within time. Within 45 days time prescribed by the.
Yes, we have understood. Thank you, Mr. for assisting in such an effective manner. Thank you. Yes. Anything else?
My Lordship, with regard to the, I am ready to deposit within 15 to 20
We are not.
days.
This all you should advise your clients properly about the remedies. Don't ask the court what should I do by filing a petition.
My Lordship, may kindly consider page number 57, my Lordship. My Lordship, page number 57.
You understood.
My Lordship, kindly, I beg to submit. I beg to submit only considering page number 57, my Lordship.
No, Mister, we are not sitting here to convince you.
No, my Lordship.
Till you feel convinced. We have understood this is wholly a frivolous petition. Your remedy lies in challenging the order dated 28/7/2023 by which your appeal has been dismissed by Debt Recovery Tribunal. That you are not doing because you know that you will have to pay 50% of the amount before appellate tribunal, probably, correct?
Yeah, I'm the third party, my Lordship. I am not the borrower, my Lordship.
We don't know.
My Lordship, at page number 57, my Lordship, only one humble submission. The bank
No relief in this petition can be granted to you on the facts stated by you itself. You are seeking extension of time of 30 days which expired in 8th of July 2022. Thereafter, your appeal itself has been dismissed as barred by limitation. You are not challenging the order dated 8/7/23 and seeking extension of time. This is frivolous or not? Obviously, we will say so and impose cost of 15,000 rupees.
No, my Lordship,
Frivolous.
my Lordship,
In this petition under Article 2.
I will withdraw, my Lordship. My Lordship, may kindly consider what is the pathetical situation of the present petitioner, being a mother, filed the so and so, my Lordship. My Lordship, may kindly permit me to withdraw, my Lordship.
In this writ petition, the petitioner has asserted the validity of the order dated Challenge the order. 18-7 now, whatever.
Item 13 reads a
This was 11. Which this number was? Previous one, you gave 11. Notice.
Wait, please.
Double yes.
Right.
Petition is admitted for hearing. Notice on behalf of GP Health and Mr. Prabhakar Rao, Learned Counsel for respond number 2. To note the date. What were you doing?
The applications have.
No. Tell us, when was the examination held? NEET examination.
NEET examination is conducted on the prospects for.
No. When it was held, Mr.
Let the Lordship kindly.
March PG examination, when it was held? March 23. You appeared in March 23.
Yes.
And thereafter, what happened? When was the result declared?
Result declared in the month of May.
So any of these 31 days, right, which you don't know, right?
Notification for PG admissions is issued on 8/8/2023.
8/8/23.
Yes. And I have submitted my application on 9/8/2023. And the submitting for online application is ended 16/8/2023. 16/8/2023. And
so what is your grievance now?
Now the
you
government
submitted application on 9/8.
Yes.
Right. So what is your grievance now? What interim relief do you want?
My grievance is that the article, as per the article 371 D, the government.
Like same like the person who studied in Karnataka, you want admission in a MD dermatology, and at the cost of this thing, university will sponsor your education.
No.
And allow you to travel free live.
No. This is not. I am the permanent resident. I am the permanent resident of.
Are they not entitled to respond to your prayer?
My prayer?
Prayer to file counter, sir.
After by the date of counter, the merit list will be released, and all the students will be admitted in the courses, and my writ petition becomes infractious. And the very purpose of writ petition will be defeated.
So you should be admitted to MD radiology.
No.
Which branch you want?
I am.
Asking.
My grievances is there.
No, which branch you want admission in Hyderabad? Which branch?
No,
Did you not ask the petition?
No, my lord.
You don't want admission.
No, my grievances is that the government have issued the prospects notification
when was that prospectus issued? 8th of August.
8/8/2023. Kindly see the page number.
Fine. So what were you doing? 8th of August 23, you knew that this prospectus did not make a provision for whatever reservation belonging to people of Tamil Nadu.
No.
But Telangana.
No, Telangana.
Telangana.
Because the presidential order, 85 seats up.
Problem is, mister, if you don't listen to us, what you say doesn't matter. What we write matters, right? Otherwise, by now you would have admitted him and given him a copy duly signed to Mr. Rao.
I apologize.
That writ petition is allowed with cost of 2 crores, and you should admit him just now.
I apologize.
But it can't happen. What we write matters. So therefore, always be attentive to court.
I submit minute.
You have not told for, we have already admitted your writ petition. You have not so far told us that what interim order you want.
Yeah.
And you are arguing.
I am seeking the interim order for suspending the para 2 clause 1 of, which is saying that in the Telangana seats, management seats, all over India, candidates should be appear and take this.
100% all India. No Telangana person will get admission in management quota.
As per the,
No, what is the case? We are asking you. No Telangana person gets admission in management quota. Everyone who is a domiciled out of Telangana gets admission.
No.
100% reservation you are saying that is been created excluding the person of Telangana. This is the case.
My case, my condition is, my case is that 85% as per the presidential order, 85% of the reserve seats in the management quota has to be reserved to the Telangana state. As per the AP reorganization state. Page number, kindly see the page number. Page number 66, ma'am.
And they said because in order to protect the actor, the seats are being held on. We are just proving that also that seats are. Now they made it open to everybody.
Mr. Pravakar, this entire management seats are open for everybody.
Open for all, Lord.
They want a reservation of on the basis of residence.
Presidential order, available seats, Lords may say, available seats is defined below the presidential order. Lords may I just take your Lords to the.
Yes, which page?
Lord, the page 48, Lords.
48. Yes.
But available seats. But may permitted to read, Lords. But in relation to any course of study, means number of seats provided in the course for admission at any time after excluding those reserved for candidates from outside the state.
So what is the non-local 15%?
15% is merely 3 local areas in competent authority quota. Not is a management quota. Unaided private medical colleges, but 50% they are contributing. Without any aid from the government, they are 50% of seats they are contributing to state to fill up. Remaining seats are divided into 3 categories. Management quota.
So like 50% seats of private educational institutions are government seats against which
yes,
this thing you can admit as per merit.
Yeah, as per merit, following the presidential order. Remaining 50%, Milord. Remaining 50%, there are 3 categories, Milord. 2% of seats are management seats, 15% are NRI seats, 10% are institutional quota seats.
No, 25% are this thing, 15% NRI and
15% NRI. Management quota. Management, sorry, institutional quota. But there cannot be any further reservation under management quota.
Management quota.
As they are, Milord, they will fill up.
This thing we are not getting because these people don't assist us anyway. He has not brought any this thing, but according to me, if my memory serves me correctly, domicile, the reservation based solely on the basis of domicile solely has been held to be impermissible. Probably that decision is somewhere between 89 to 94. That was the first decision.
Yes, sir.
Thereafter, this issue must have been dealt with. We cannot expect him to bring that case law and argue. He is only this thing. 1 minute. 1 minute. We will hear you. We are understanding the legal issue. No order will be passed without hearing you. But you must come that well prepared.
Yes.
Did you tell all this which Mr. Rao is telling?
But I will file. If my friend is saying, say I will file counter within 1 week, Lord. Within 1 week.
The government of Telangana has issued a GOMS number 40, wherein the page number 37, my lord.
He wants, Mr. Rao, the difficulty is that you are so reasonable. that you will file within one week. But he wants admission letter right now, before 12 o'clock.
No.
We are admitting the petition, Mr.
I'm in respect of releasing the merit list. I'm not seeking any admission. I'm
No,
in
see,
respect of.
Mr. He said that merit list will be released in one case within 2 weeks. And before that, he's saying that I will file counter in this case. You are not getting it what to do. If you want us to pass an order and if you are ready to go to Delhi, please tell us. We will pass an order on merits right now. That no case, a case for a grant of ex parte order is made out. We will reject it. You tested before.
One submission, one humble submission.
Other humble submissions look behind. Everybody is waiting. This is the result, despite the fact that we are admitting the writ petition, not dismissing it.
1 week.
He said so.
1 week. I will file 1 week. I will file 1 week.
1 week.
Yes.
By the time merit list,
Nothing will happen to you.
if the merit list is released, everybody will take the admission, and my writ petition will become.
Fine. We are rejecting your prayer. All right. You want an order on merits, we are rejecting your prayer for
only 1 second.
Add interim relief.
The government of Telangana issued a GOMS number at page number 37, GOMS number 40, wherein they have specifically and categorically admitted that the presidential order Article 371 is applicable to the competent authority quota as well as management quota also. At page number 37, they have clearly admitted. Now he is stating that management quota is not applicable.
No, you will be respondent in one of the cases on advance notice in some case. And we will decide that writ petition or appeal that very day without giving you an opportunity, then you will realize. I mean, what is this, Mr.? What are you? He said in so many words that the result will be declared after 2 weeks. Before that, he will file the counter. You want an order on merits. We have no option but to reject your prayer.
No.
And no problem in rejecting also. No case for grant of ex parte stays made out. We will say so. You want it, right?
This grant. I apologize.
No apology, Mr.
Picture of a PG student is.
No, he is safe. Once his writ petition is admitted, we have power to nothing. If it's that and your understanding of law, we are sorry. You have then under assessing the powers of this court. We have power to sanction a post for you.
I apologize.
And to this thing, direct them to give you admission. We have set power to do what has been done.
Apology.
Undo what has been done. You are saying infructuous. We will record it. And remember, next time that moment he publishes the merit list, we will say your petition according to petitioner has become infructuous, therefore dismissed. What this? Learned, yes, heard on, mark their presence, Learned Counsel for the
Wait, please, your lordship. The appellant before your lordship is respondent number 5 in the writ petition, my lord. Challenging the order of the single judge.
Yes. Yes.
The learned single judge, my lord, did not consider the fact that the writ petitioner claiming rights over a second gift registration sale deed, my lord. The first register sale deed executed in favor of the appellant has been cancelled unilaterally. That has not been considered, my lord. The writ petition has been allowed solely on the ground that the tribunal passed the order in the revision, dismissing the revision petition, and one of the members of the tribunal is the RDO who passed the same order, cancelling the entries made in favor of the writ petitioner, my lord. May I permitted to pass on a brief note, my lord?
What you are arguing finally, right? Huh?
The issue involved is a unilateral cancellation of a gift deed, my lord. The mother of the appellant executed a gift deed in 2004. That has been accepted by me, by the appellant. And later on, she executed a unilateral cancellation of a gift deed in 2008.
Thank you, Mr. for this.
Oblige you.
First gift deed execute mother of the appellant. Cancellation gift deed, date of second gift, writ petitioner and his brother.
When I applied for mutation, my lord, the RDO, the Tahsildar issued a memo challenging the same. I preferred an appeal before the RDO, my lord. RDO cancelled the entries made in favor of the writ petitioner and agreed by the same, he preferred a revision. The revision has also been dismissed by the tribunal, my lord. Challenging the same, writ petition has been filed.
Cancellation of gift deed challenged before any authority?
A civil suit has been filed subsequent to the passing of the order. I have mentioned in column number 7.
Once you have challenged the cancellation by filing a civil suit, are you not required to await the result of the?
Yes, that's what the single judge also. If your lordship pleases, my lord.
That's what I mean. The correct legal position.
My submission, your lordship. The entries in favor of the writ petitioner are based on a second gift deed.
Entry does not confer any title revenue entry. This thing will.
Suit is allowed, automatically.
Your name will get into it.
If your lordship pleases, my lord, I may permitted to say one thing. I am confining my prayer here. Let the writ petitioner also shall not make any create any third party interest.
He can make such request in the suit, lordship. Suit pending.
File an application for injunction. He is a party to the suit.
Thrice the orders have been delivered in my favor. Revision petition has been allowed.
You want orders from all courts, for trial court, high court, then you will go to Supreme Court also say, please grant restrain him. So then what will happen? All orders. If there is an order, he cannot restrain, he cannot sell the property. And if he does so, 39(2)(a).
Lordship may give me the liberty and dispose of the writ appeal.
What liberty?
Liberty to approach the civil court.
You are already
under 39.
It's always open to you.
Kiran, you already filed a suit.
The suit has been filed. My submission is
2022.
My apprehension, my lord. He may create third party interest after passing of the orders in the writ petition.
Do it tomorrow, Monday morning. Who is stopping you? Before he can identify a buyer.
Shall you say that you withdraw this writ appeal with the liberty to file an application 39(1) and 2? In that case, we say that in case such an application is made, trial court shall consider it expeditiously. Right?
I'll
mark the presence this intra-court appeal. Oh, thank you, but thank you for this.
Oblige.
This is what we want from everyone. This is what people argue for 1 hour without this giving us this. Thank you. Really, we appreciate irrespective of the result. Keep it up. At least in court hall 1. This intra-court appeal has been filed against an order dated 20th February 2023, passed by learned single judge in WP.
Is not respond number 5, respond number 1 and 7.
1.
1 and 7.
1 and 7. We said 1. 5. So writ petition filed by 1 and 7.
Writ petition filed by only 1.
1. Writ petition filed by 1.
Much.
Yes. Yes.
My lord, this matter was referred to the committee. So I appeared there and then I was allowed by the committee to represent this case here. So I'm here.
Let's see whether the decision of the committee was correct or not.
Probably.
And that we will determine with reference to what you argue.
Yes. So briefly, the matter is, I am a complainant in the lower court matter. So here now, without any.
You are seeking a direction.
Yes, Lord.
Metropolitan Magistrate,
Yes.
Hyderabad, to proceed with trial in CC number 1070 /2070/2017.
Yes, Worship.
And you must be knowing that the trial of this case is not proceeding on account of stay operating in CRLP number 4877/2023 filed by
Yes,
respondents 2 and 3.
Yes, Lord.
So we cannot, one bench grants the stay, other division bench says that you proceed, can't be done. What is your remedy? Remedies to intervene in CRLP 4887 of 23 and to file vacation of stay
Yes. That has
instead
been
of
done.
filing a writ petition.
Yes, Lord, one submission. I have filed a counter and after that the matter did not come on the bench.
Go seek a mention memo.
Yes, Lordship. I'm even come to that. Now what has happened is there is no stay now as of now because the extension of stay was it lapsed on 36 itself.
When was the stay granted?
It was only until 30th June. The stay was granted.
When was it granted? Stay first of all, CRLP number, when it was granted?
It was granted on 7th June.
7
and only
June
after.
20, just a minute.
Yes, Lordship.
7 June 23.
Yes, 7 June 23.
And where is that copy of the order saying that it is only granted till 30th June and
that
will
is
not
there.
be extended?
The copy is that
Page.
they have actually filed for 3 petitions.
No,
they
no,
have
no.
filed for stay.
Where is the order? First tell us 7/6.
The copy is at 69, page 69 to
16.
67 to 69.
67 to 69. 67. Having learned senior counsel till 30th 6. Then what happened on 30th 6?
Now after that I filed a counter. And once the counter was filed, the matter did not come on the bench.
On 30th 6. After 30th/6, it has
It
not
came,
listed.
it was supposed to be listed on 26th June.
No, 30th June 23.
30th June, I represent
says-
the bench. I represent on the
No,
bench.
mister, please understand. Try to listen to us. Page 67, you told us is the order.
Yes.
The order says interim stay till 30th/6.
Yes.
The case was directed to be listed at the last line you can see at page 67,
Yes.
30th June 23.
Yes.
Then what happened on 30th June?
30th June, I represent the matter.
No,
And then I took
that's
permission.
fine.
I took permission.
What happened to the case?
It was extended again.
Where?
This stay was,
Where is
that
it
is-
of?
there is no order as of now which is actually printed or it is available on the website.
That then stay order operates.
It operates only after 26th June again. So that has lapsed.
How?
Lordship, there is a recording. There is a recording of the lower trial.
No, mister.
Yes, Lordship.
The page 67 itself, it says that order is granted till 30th June 23.
Yes,
How can you say that it operates only till 26th June 23, contrary to the order passed by the court itself?
26th July.
You are saying June. Did you realize this?
Yes, Mr. Yes, Lordship.
It was so therefore simple cases that you on 30th/6/23,
Yes.
it was extended up to July.
26th July.
Then
Thereafter, they filed an interim stay month for extension of the interim stay. The matter did not come on the bench. And there was
therefore you thought that we should seek a writ petition and direction.
no,
be
no, Lordship. Please, one humble submission. There was some hearing of the trial court matter on again 10th on August. 10th August. So the recording of the trial court was that there is no stay. The stay is only until 36, 2023. However, the matter there is the case status are filed as with a memo, which is at page number 91.
All right, we will issue
So
notice.
there is no Lordship.
So, 13% committee this time appears to be right after hearing your argument.
No stop.
14% heard on the question of admission. Yes.
GP for revenue.
Made, please, my lord.
You are an aggrieved person, right?
I'm the petitioner, my lord.
No, you are an aggrieved person.
No, my lord. I filed this petition as a public interest litigation, my lord. Being a localized and villager of that locality.
Madam, give it to him. He is standing. Let file. So he can correct the cost at just now. Delete as per order of the court and sign it.
My lord.
No, who are you?
I'm the same village person, my lord. I'm the same village person, my lord. And I'm social servant, my lord, doing social activities in my area.
What social activity?
Pardon.
What social activity have you done?
My lord, I'm a religious category person, my lord, to leading the people in my.
Religious category means there is a religious category.
I'm a person who's serving the people, my lord. In meanwhile.
No, everybody is serving, like all their employees of Union of India and Mr. GP for revenue are serving people.
My lord, I submit that, my lord, I'm a person who selected for my category people to represent all these activities in my village, my lord.
You this thing the PI must be in a form, right? Yes. And
I submitted myself in page number 14.
Yes. He is required to disclose his antecedent. There are see nothing. Public interest litigation, the sprint of so and so house. Read your public spirited antecedents. What have you done? Paragraph 2 and 3. We don't find anything.
In page number, my lord, 14. Pardon, my lord. Which page, my lord?
Contents of the petition. Where else?
My lord, page number 14.
No. I mean, we are required to tell you that page.
No, my lord. Pardon, I did not get the page number, my lord. So that.
No, we are asking you about your antecedents. How are you a being resident in a village? Does not make you a public spirited individual, right? You should give the antecedents.
Lord, that was
this is all this thing. Innocent purchasers can come to the court. They don't need. Have they authorized you to file a petition, innocent person, and said that we are so poor and illiterate that we can't come, therefore we authorize petitioner to file a petition on your behalf? Where is it? There, our behalf.
My lord,
nothing.
That is not there in my petition.
You are an old person, 60 senior citizen, right? You should live in peace. Instead of coming to the court. Courts is not you should go for this. See, Mr. Read whatever. Page 10.
Page number 14, my lord.
Particulars of petitioner and locus standi. What have you said? Please tell us.
That was, my lord, page number 14, para 1 I mentioned, my lord, about myself. Please permit me to read, my lord. The petitioner also social work and uplift of the downtrodden innocent people from the government land from the grabbers, my lord. In this petition, my lord.
No antecedents given.
And the particular of petitioner, my lord, page number 10, I mentioned.
So you are not prepared to give antecedents, right? Relying on para 14, page 14, right?
Yes.
Correct.
And details of myself, my lord, page number 10, my lord. The petitioner details I mentioned in para number 2.
No, this thing goes cheating and all that. Yes. That's it, Mr.
I just want to submit more things, my lord.
More, but first answer the query. There are no details of your antecedents. So you have read page 14. That's it.
No, my lord. Page number 10, the details of the petitioner, my lord, and the locus standi mentioned in page number 14, my lord.
That is what we have been asking. Please read.
My lord, please. It is submitted that, my lord. The petitioner also social worker and
no, this is self-declaration that I am a social worker is not sufficient. You have to satisfy the court. Nothing. What have you done for the society?
For that, my lord, page number. Permit me.
No. So you are not saying anything here except saying. And who is selling the property? To whom? And what fraudulent property?
I submit one by one. My
No.
Lord. Permit me.
So you went to the office of respondent
Yes,
number
page
10.
number 67.
No. We are telling you off the record.
Yes.
You went to the office of respondent number 10, demanded money, they denied. So therefore you filed a petition here. It's like this story, this extortion tactics.
It happened in 67 page number, my lord. Permit me to read.
Read whatever.
As RTA, my lord, I applied to the Mandal.
Thereafter, Mr., we will not grant you time, right? Argue whatever to
Yes,
your
my lord.
content.
My lord, the Mandal Panchayat.
This is
officer-
on admission.
Permit me, my lord.
Yes, yes.
In
of course.
Mandal Panchayat officer, my lord, I applied a RTA letter stating that some illegal activities going on the server number. He replied, my lord, for me. Page number 68, my lord, English translation paper. Page number 67, original paper in Telugu. Okay. This 1 point is the only now we can schedule from. To be satisfied, go through this, that is, go through the primary. One week. Yes. My lord. Page number 65, my lord, please.
Yes, yes, go ahead. Don't look at
My
us.
lord, what-
We are listening. Multitasking. So we are listening also, and
Permit me, my lord.
it is simultaneous, right? Go ahead. What?
My lord,
Don't look at us. Others are waiting, please.
this is the document, my lord. If you want to read the document, my lord, then the rest of the court, my lord. This is the agreement which is given by the 10th respondent, my lord. At the time of registration, he admitting that, my lord. Please see, written by the Gangavarapu Chinnakishan Reddy.
Which document?
Page number 65, my lord.
65. Executed in your favor.
It's not my favor, my lord.
Then,
My lord, this is the interest of the public, my lord. He's cheating by the way of open the patramu. I came to know my notice, my lord. I cannot keep silent in my village.
it's not your land, right? Agreement not in your land.
No, my lord.
Then, yes.
And page number 16.
What agreement is?
My lord, 64 is the
1 minute. We are under, you just now 65 said.
Yes,
we are trying to understand it is executed between whom? Who are the
one of the purchaser and 10th respondent, my lord. 10th respondent, the landowner, he is selling the plot to the innocent purchaser.
No. Where is?
My lord, please see whom it is noted. Saipriya is the purchaser, my lord. And written by Gangavarapu Chinnakishan Reddy, 10th respondent, my lord.
So, what happened to
And he
this
undertakes
Saipriya thing, right? Saipriya, what happened?
She
He is not coming.
She is the one of the purchasers, my lord, in the said layout in the village Kartal. I submitted the sale deed also, my lord.
Sale deed executed.
Executed, my lord.
So you are representing the allottees of in a layout developed by respondent number 10, correct?
Yes, my lord.
Representing the allottees in layout developed by layout developed by respondent number 10. So, what is your case that this layout is illegal? All these purchasers should be thrown out, allottees.
Yes, my lord. What happening, my lord?
Allottees should also be thrown out from this, their area in their occupation.
My lord.
These allottees, I mean, from this respondent number 10.
Yes, my lord.
What is their grievance of those allottees which you are espousing here in one line, and then we read everything?
Permit me 65 page only, my lord.
No. So what is the grievance of allottees who are not before us?
My lord, he taking the price for 188 square yards. 188 square yards. And he registering 160 square yards. And remaining 28 square yards, he giving this declaration of paper 65, my lord. In future, if I acquire the property, I may register for 28 square yards. He is admitting that the land is not available to register now. This is the letter, my lord. My lord, please see, my lord. I read out this 2 lines, my lord. I finish my argument.
Please.
My own plot, Rangareddy district, Kartar village, survey number 8, plot 35, containing of 188 square yards. On my own plot at now 160 square yards. In this plot, said my lord, Cypress is the only one I registered. And I decided to sell the rest of the plot for so and so amount, and total amount of 58,000, my lord. See, my lord, I am writing this agreement because this place is not available for registration now. This is clear admission by him that my lord, place is not available. Even though he taking from innocent purchasers, he creating the layout without any due permission, my lord, which is brought notice before the Mandal Panchayat officer also, page number 68. He given a false reply that he did not know anything.
But you have not challenged this plot agreement in the writ petition. We have seen your prayer. Prayer is something fraudulent transfer of sale deed and encroaching of government land. Which government land he has encroached, and where have you made a complaint to any authority before filing the writ petition?
My lord, for the same reason, my lord, I filed 2 sale deeds, my lord, to show the locus.
No. Prayer clause 1 is fraudulent transfer of sale deeds. Second is encroachment on the government land by respondent number 10. So which government land he has encroached, number 1. Second is, have you submitted any representation to any authority before coming here?
Yes, coming to the point, my lord.
That's important.
65 page number, my lord, he is admitting that.
Everybody is waiting that you come to the point quickly.
Only 2-3 minutes, my lord. Apology that.
Yes.
My lord, he admitting that the place is not available.
Representation dated when?
Yes, well, page 68 page number.
68. Representation dated Gram Panchayat.
No, my lord. Mandal Panchayat officer.
A vessel of their faith. Who has submitted?
My lord, RTA filed by one of the petition, one of the own village resident, my lord. By this letter only I came to notice.
No. Who has addressed this? Please see 68 4323.
My lord, to the Srikanth Reddy, Kartal Gram Panchayat.
Who is Srikanth Reddy?
My lord, he is also villager, my lord. I came to notice.
No. So representation is given by whom? At the bottom, see right hand side of the page.
Yes, my lord.
Who has given?
Representation given by the Srikanth. My lord, this is the reply letter, my lord. Please permit me. Representation made by the Srikanth Reddy for.
We want to understand. We'll go through it. At right hand side, at the bottom, what is written?
Mandal Panchayat officer.
No. Above that, a vessel of their faith. Who is vessel of whose faith?
Page number
what is written?
Mandal Panchayat Prajat officer, Rangareddy district.
Above that, Mandal Panchayat officer. Above that,
to Srikanth Reddy.
Either our document is something else, or you are not deliberately reading it.
Page number 6.
Page 68. Here.
Yes,
what is written?
Mandal Panchayat officer.
There is a space above that line. That's all. There only.
A visual of their faith.
Who is this person? Vessel of their faith. Who is this?
This
is not the name of the petitioner, right?
No, my lord.
We asked you whether petitioner submitted a representation. You said 68. Yes, then we are asking you You are not a vessel of their faith.
It is given by the authority person, my lord, who is the panchayat officer signed, my lord. This
What is this vessel of faith? Please explain.
Pardon, my lord. See, my lord, one of the villagers submitted the letter to the panchayat officer, my lord. In that reply,
No. Simple question. That we will come to it, whatever written.
my lord.
Who is this person, vessel of their faith?
My lord, Tama Vishwasa Patru in Telugu, my lord, the vigil of the faith, my lord, once he addressing the letter, he given this stamp to me.
Yours faithfully or yours of reading?
So yours faithfully, right? So say that you make an English translation of yours faithfully, a vessel of their faith. So we are wondering who is vessel of faith.
My lord, this is not my sign, my lord. This is the person who gave to me reply.
Yours faithfully, right?
Yours faithfully.
And this is so you should immediately say that it is a case of incorrect translation. I am sorry, sir. It says your faithfully.
See, my lord.
Please appreciate. I can't read Telugu, so my lord has read it, and he argued on your behalf that it means faithfully.
My lord, the Mandal
What
Panchayat
sort of
officer,
public interest
Mandal Panchayat officer saying that the Vishwasa Patru means he.
No. So you have not submitted this representation. This representation is
Shrikant Reddy.
reply by Mandal Panchayat officer to Shrikant Reddy.
Yes, my lord.
So where is your representation about encroachment?
Yes, my lord.
What is this, Mister?
I mentioned in my writ petition, my lord.
No. Where is the representation? You said 68. 68 is not by you.
Not by me, my lord. One of the other villagers.
No representation by you, correct?
Directly not by me, my lord. Directly not by me.
Fine. So would it not be better that you approach and file petition then, or we pass an order? Choice is yours. How can you straightway fly to the High Court?
My lord.
Like from village, just trying to.
My lord, I am not for in this bill, my lord, because any person from the village can file bill, my lord. See, the information sought by me by one of the neighbor villager. If the court
You understand that you have not submitted any representation to any authority about your grievance and straightway filed a public interest.
My lord, page
litigation.
number 17, I mentioned, my lord.
All right. Thank you.
Please.
We have understood. Thank you. Mark the presence. The order follows, right? He did not understand what to do. He doesn't want to this thing. Pro bono he is doing, and pro bono is this petition.
Lords, request your lordships to grant me permission to withdraw the PIL, your lordships.
Sustain, office objection, no, which case? This, it's on office objection, what? And therefore, office object, for the aforementioned reasons, right? Office objection is also sustained and petition is dismissed.
My lords, I request your lordship's permission to grant me liberty to withdraw the.
Correct, right. Was so nice that we were inclined to impose costs this time.
Pursuant to the mention, your lordship.
Correct, you thought about it, no? It's all like, we all have practiced, Mr. We can read between the lines. You have to give us the benefit of experience of 20 years spent at the bar. This all, we all of us have defended so many public interest litigation. I was never a public interest litigation lawyer, but I always appeared for respondents. So I know what my clients used to tell, what the petitioner has done, how much demand he has made. Then he has threatened to file a public interest litigation. What that villager was doing just now, you saw, right? Went to the office of builder. He must have turned him away. And he said, all right, I will see you in court. Learned counsel for the petitioner seeks leave of this court to withdraw the writ petition on the ground that the withdraw the writ petition. Paragraph, the petitioner appears to be an aggrieved party in the context of prayer. Petitioner appears to be an aggrieved party, which is evident from perusal of the prayer clause. We therefore permit the petitioner to withdraw the writ petition. That's it. With the liberty. With the liberty to approach the forum which may be available to him in law with regard to his grievance, if any.
Oblige,
GST, that's all that they. GST without registration, they can complain to the state council, then there's another council is also there, which can look into CGST or state. Yes, please.
Well, on the last occasion.
What, you have filed counter?
Well, we have filed counter. And one more thing I want to bring it to your lordship's attention. The matter below Order 39, 1 and 2 was heard before the learned single judge on 9th, 14th and 18th, and the judgment has been reserved.
No, you come to that.
He wants to. No, but it is not for, it is for admission. We will admit it.
No, my lord.
We have a bunch to deal with the students whose results have been withheld.
True.
So
my
we can't,
your lordship had requested me to file a synopsis.
But conclude in 5 minutes. Not you on that day said I will take 1 hour. I have never heard in my life arguments on 39.3 for 1 hour.
My lord, it's order 39, 1 and 2. See, my lord says, I'll pass on the
ex parte order of injunction.
No, I'll pass on the.
We'll admit to what.
Mr. Ramkumar, matter is heard and reserved.
My lord, it is heard and reserved, but the question which I am raising here is that the injunction should never have been granted.
That is true, but today, once the matter is heard and reserved.
We don't want to examine it. The validity, whether it is rendered academic, will be decided.
My lord,
at this stage, we do not have the luxury today to examine the validity, whether it should have been granted or is it a fit case to court ought to have granted or not to have granted. Today, we do not have that luxury because the Honorable Chief Justice has already indicated today we have fixed a specific matter of students are being taken up. Where the
results are withheld MBBS entire this thing.
I understand, my lords. Then
we will hear you. If you still want to address, we will admit it. We will hear to some other day, but not today.
My lords,
If you still,
should I have it on Monday?
Monday we have 76. We can have it on Tuesday.
Deeply obliged.
Appeal is
We'll have
admitted.
it on Tuesday.
Appeal is admitted for hearing.
My lord, could it be Wednesday, my lord, 22nd? I'm in some difficulty. I've come from Delhi, my lord, for the matter.
Oh. So when was the arguments heard on 39, 1 and 2?
My lord, they were heard on 9th, 14th and 18th. That is
9th,
14th and 18th. Yesterday, my lord, also, they were heard for almost 2.5 hours on each day and judgment reserved.
My lords, it is open now for filing written arguments.
And 19th August and reserved for judgment.
Yes, my lord, it was reserved yesterday.
18th.
My lords, it is posted to 23rd.
Delete.
My lords, it is posted to 23rd for filing written arguments.
this-
Judgment is not yet reserved.
No,
They
judgment
said-
is
they
reserved,
said-
please.
they
25th
said you-
August.
On 23rd, written arguments would be filed.
Judgment has been reserved. My learned friend should not make a wrong.
Where is the order sheet?
My lord,
You
we
have-
It's a, we don't have the order with us, my lord,
Yes.
but the judgment is reserved. I'm making a statement.
So, no. So you produce
My
that
learned
on
friend
next
counsel.
date. Produce it on the next date that judgment has been reserved.
Yes, I will.
All right.
I will.
This appeal has been filed against an ad interim order Please.
Right, item number 19, Malat, senior counsel is appearing. Before minute, senior counsel starts, Malat. Right, insofar as fourth appellant in W at 324 minute, I may permit to withdraw, Malat. Only insofar as appellant number 4.
Permitted to withdraw?
Insofar as appellant number 4 only, Malat. Remaining Malat, senior counsel will.
All right, yes. Mr. What's your name?
Muhammad Islamuddin Ansari.
Learned counsel has appeared on behalf of appellant number 4 and has filed a memo seeking leave.
Oral instructions.
Then you will say that I was not given instruction.
Because
I
our
don't know
practice
you.
is that they sign on the,
I'll sign.
they sign on the document. Council signs
So
on.
normally what you will do is that you will produce a memo seeking leave of the court. So there is something on record. Otherwise you
Normally
will
what
say
happens now,
that I am not somebody else will come. I am so and so.
that can be done, my lords, but the practice in our court is.
Identify him, right?
Yes, of course I do.
Later, when learned counsel for the appellant number 4 seeks leave of this court to withdraw the appeal on behalf of so and so, he is permitted to do so. Item number 19 and 20.
19, only insofar as appellant number 4 is concerned.
19 and 20.
20 minutes, no.
No, you don't want. Then
Senior counsel will take.
all right, yes. So then we will.
My lords,
What to be done, Mr.
chronology of events are before your
Correct.
lordships.
So why, Mr. Ravichandar, this thing we thought that Saturday is an ideal day. What has happened that Mr. Prabhakar Rao has given an undertaking that he will not declare the result of MBBS students. That bench has to be heard and order has to be
I
passed.
understand.
Everything is.
May I request your lordships to have it on
So you
Tuesday,
will
subject to your lordship's calendar,
that
Tuesday. Minutes.
Tuesday we have already.
If it's not Tuesday, next week, the week after that, any day. Minutes.
Next week. What?
Week after means week starting from 28.
28. It can come up on 29th August.
Yes.
Trouble is only those 2 dates are tight for me, my lord. Kindly have it in first week.
First week.
I have some partners.
First week is 5th September. It's fine. Mr. Yes, 5th September.
Yes.
Mark their presence list on 5th of September 2023.
Take our endorsement.
Because the interim order may be extended.
Interim order
Yes.
shall continue. Till next date of hearing, list on 5th September. Yes.
20 no, they said they also have chief minister.
So 20s also goes along with that on 5th September. 21.
I think 20 Stephen was for the.
Yes. Not getting instructions, so shall we assist you in getting instructions? Huh? No, this is how much time he shall pass the final order. This is what, and you are unable, you should say without telling him, you should tell us that within 3 weeks he will file. Hey, all this, Mr. What happens? Same thing. Then the list goes 100, above 100, 140. All this is because these cases are repeated. Let him.
Interim orders may be extended.
You are not in a hurry. The learned counsel for learned government leader once again prays for adjournment to enable him to seek.
Wait, your lordship, my lord, your lordship considered a similar matter, my lord, same batch. Lordship passed interim orders.
Not bring the subsequent trigger
And directing that electricity connection.
pass an order following the
Order.
Chelsea Ninan
Yes.
2023 SSC.
Yes. Same order. You appear for respondents, right? So we should write maybe here. Respondent, learned counsel for the petitioner. You place appellant. Appellant places reliance on decision of Honorable Supreme Court in so and so versus so and so 2023 SCC on line 663. Learned counsel for respondent number 2, praise fund is granted. Give 3 weeks, but 3 weeks instead of 2 weeks. 3 weeks time to file IA2 direction petition or stay whatever. Yes, 23.
Subject to your lordship's leave. I'm passing a brief note.
Arey, Mr. Yes. So this is an order under section 40 or 13, 4 of surface.
Milord, this order is passed, Milord, under Recovery of Debts and Bankruptcy Act 1993, Milord. Because the bank.
93 Act.
Yes.
So which provision? Section 19 provides for.
19, Milord.
19 provides for an appeal.
Milord. Then after 19 order, Milord,
Yeah.
they filed.
No,
Milord,
the 1 minute, let us understand. Order dated 19/5/2022 was passed under 93 Act.
19 of the.
19/5/22. You challenge that order in an appeal under
Milord.
section 19 of 93
I
Act.
did challenge, Milord. Subsequently, Milord, the respondents filed, Milord, for recovery of certificate under section 25 to 29 of the Act. For recovery certificate. Then, Milord, the DRT, Milord, passed recovery orders under section 25 to 29. Then appeal lies to under 30 of the Act to the DRT.
So you filed the appeal under section 30.
Milord,
You
because
should file.
Subsequent orders passed.
So it has, it has become useless in view of subsequent order. Challenge has.
Question both orders. Under in appeal also, I can question both orders.
Learned senior counsel for the petitioner fairly submits that subsequent to the
Recovery of Debts and Bankruptcy Act 1993.
Recovery of Debts and Bankruptcy Act 1993. Admittedly against the aforesaid order and appeal under section 19 of the Act lies.
Under section 20.
20 of the 1993 Act and appeal lies. The
19/5/2022, Mila.
Huh?
19/5/2022. Sub blank is the order, consequential order, Mila, under section 25 to 29.
25 to 29, madam, we had
It's
kept blank.
19/5/2022.
19/5/20.
The second thing, Mila, instead of 4 weeks, Mila, 8 weeks.
No, no.
Mila. I need to go some other place to file.
Oh, brother says 4 weeks is too long.
For filing an appeal,
How much time does it take?
if you file today, take steps to get it listed next week. Before 4 weeks, you will also have the stay.
We will share an experience with you.
Yes.
In Karnataka, I was heading a division bench. We passed an order. Within 72 hours, SLP filed our order confirmed. 72 hours. So, like if it can happen in Supreme Court, then definitely.
Yes, published.
Yes. Yes.
The petition, this is,
Wait, please,
if I recollect,
Huh?
enrollment batch note.
Yes.
May I seek a lordship's,
Waiting in the wings, yes, chart thing.
may I seek a lordship's indulgence to pass it on?
How much time will it take, Mr.?
But this will take some time.
Time then. Probably you were there in the court when we said that students are waiting.
Your lordships may have this matter immediately after that.
If time permits, we would like to have it.
This also is an important matter
Fine,
because
pass over. They are losing substantial amount every day.
the petition, losing substantial amount is one part of it. They have to appeal.
They are also in a
the
hurry.
exam, that is why they are.
Yes.
Well, the
No,
All
correct.
India bar exam is also not.
Pass over. Pass over, right? The Bar Council is contesting your claim seriously. We asked them, you didn't tell us to prepare this thing, you didn't help in, so he has prepared a chart for you. For us rather, not you. All right, pass over, madam. If time permits, then we will take it up. I don't know, we don't know how we are.
I have to acknowledge that the chart would not have been possible, but for the information furnished by the council.
Correct. So it's a collective effort.
Because the initial papers were not filed along with the writ petition, they came subsequent.
Submission, Mila.
Huh? 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 What? Mike.
My learned friend,
Please come.
my learned friend is saying that he has an identical matter and his matter is not listed. Found by
To give the number, if time permits, you will have to wait till 4, we don't know what time. Because you should ask the Advocate General, he is about to commence a matter at 2:30, ask him how much time will he take. If he says 15 minutes, fine. Otherwise, there is no point in waiting all the day.
I am at your lordship's disposal.
No, not disposal, we are telling you. You ask Advocate
I will
General
ascertain.
how much time he will take to argue.
Very well.
Yes.
I am obliged.
Pass over for the present.
Advocate General here, neither.
Not in this case, some other case. MBBS course. Yes. What is it? Who appears in item? Party in person. There is a stake. Huh?
My lord, in this case,
31.
my lord, in this case, my lord, interim orders is granted and so far now counter is not filed.
No, what is it, Mister? What is the order you have challenged?
But the order, interim order passed by this honorable court, my lord, to deposit.
No, interim order you have not challenged passed by this court. We are saying what is the order in the writ petition you have challenged. We are aware that interim order has been passed on what date? 4/7/23.
Yes.
That you are not challenging.
That we are not challenging.
That you challenged it before somewhere. Else. What have you challenged in the writ petition we are asking?
The order
dated 15/6/20. You
15/6/23 and
23 passed under section 17 by DRT.
Yes.
Against that order, appeal lies under 18 before appellate tribunal.
But one thing, my lord, in this, before going into the merits of the case, my lord, the exercise is done by this honorable court, my lord, while granting the interim orders, my lord, on the ground that, my lord,
What exercise? No exercise.
My lord, in this case, I am permitted to say, my lord. I am permitted to say.
Yes, yes, please. No, we are just asking exercise. We read the order.
Exercise is, my lord, here this honorable court is already passed an order. Earlier, honorable court disposed of the petition saying that you consider the request of the.
Don't get agitated. Don't get. We will hear. We will hear. Don't get agitated. Don't get an impression that we will not hear you. We only, what we interact is we say because we want an effective communication between us. Because our endeavor is not to prevent you from arguing. We say because you know how it is mind is working, so that you can answer. That's why we say. Otherwise, if you say that we shouldn't speak a word, we will do so. Yes, please go ahead. It's for admission. Speak into the mic.
My voice is louder, my lord.
No, fine. Louder is fine then. Speak into the mic. Yes.
My lord, my request before, earlier we filed the request before the authorities saying that I am a small person, private employee, obtained the loan for purchase of the flat.
How much loan?
30 lakhs loan is obtained.
All right.
So far, my lord, I paid 33 lakhs.
When was 30 lakhs granted?
30 lakhs was taken in the year 2012. This will be ended in the year 2031.
31?
2031. Another
20. So about 20-year housing loan.
Yes, my lord. Monthly installment is, my lord, 30,000 rupees. My lord, due to the employment, my lord, in the year 2017, I could not pay the loan amount. There was no employment for the year in the year 2017. I could not pay the installments properly. I am admitting to that. Immediately, my lord, we made a request saying that this has happened because I lost a job. After some, there is a chance of getting the job within short period. Immediately requesting because this period may be considered.
When request?
In the year 2018, 17 also we made the request. In this case, my lord, then they instead of considering my request, my lord, they asked me to pay the entire amount. At that time in the year 2018, I filed the writ petition before saying that without considering my request, they issued a notice under Surface Act. Therefore, this honorable court in the December 2022 set aside that notice and directed the LIC authorities to.
No, what dated, order dated, which page?
That copy is filed subsequent to that, my lord. I came last occasion.
21/12/2020. 21/12/22.
Page 11, my lord, I mentioned about the WPA order number 024 of 2018, dated 21/12/22. Page 11 of the
21.
affidavit.
Reassess. So then what happened?
Well, immediately, my lord, without considering, even without referring to the orders of this honorable court, without considering the division bench of this honorable court, my lord, simply again issued another notice saying that you directed to pay the entire amount.
What is the amount they are demanding?
They are demanding 43 lakhs, my lord. My lord, till date, my lord, I am paying the installments, except to those amount of 12 months or 13 months, my lord. I am not asking any that may be regularized or they may penalize me.
So, what should have been your first sentence? That, sir, I want to repay the loan. Not that this thing. When we said that appeal, you should have said that I want to repay the loan. It's not that I want to run away. But this is what I want to. And you are paying per month since you are paying now.
Yes, my lord, is.
In terms of
till date I am paying.
30,000 month you are paying.
45,000, my lord, page, my lord, lordship can look into.
Since when you statement you tell us?
Statement is page 10, my lord.
Your statement. Since when you are paying 35,000? 2017-18 you did not pay because you lost job.
Yes.
Thereafter, when did you get the job?
Yes, ma'am.
When?
In the year from 2018 onwards, my lord, I am paying the amounts.
When 18, 12 months, Mr.
I paid the entire amounts, my lord, page 9 onwards, I am mentioning 2019, 12, I paid 3 lakhs. 2013, I paid 3 lakhs. 2014, I paid 3 lakhs 3,000. Page 9 onwards, my lord.
Page 9.
Paid rupees 30,000 due to job loss. Then again, he started paying.
Mr. What do you say?
Your Lordship.
No, is
Said
what you are a bank meant for people, right? Here is a customer who is not at flight risk and wants to pay.
Lordship,
Right.
the said account.
So you work out a solution. There was a direction to restructure that you have not done. And again issued a demand notice. So tell us why we should not quash this demand notice, because simple reason that the directions contained in the earlier order passed by this court have not been complied with. Did you consider his this thing earlier order 21/12/2022? Where have you considered?
Basing on the consideration of the orders, we issued a position notice.
Where
Your
is the
Lordship.
order 21/12/2022? Madam, give it to. No time. Give. Not there. Learned counsel for the appellant prays for adjournment in order to enable him to place on record copy of the order dated 21/12/2022. No, you write. Delete. This petition has been filed against an order dated 4/7/20. No. This petition has been filed against order dated 15/6/2023 passed under section 17 of SURFACE Act. Learned counsel, full stop. The petitioner is an employee of what? Which government?
Private employee.
Petitioner.
Software company employee.
Petitioner is an employee in a software company. The petitioner had availed of loan facility to the extent of 30 lakh. Amount according to them is outstanding.
They are not saying anything, my lord. They are asking-
94,000.
That is total.
Where from? Learned
this year.
counsel for the bank submits that an amount of rupees 43 lakhs,
94,128.
94,000,
128 rupees.
128 is due from the petitioner. The counsel for respondent bank is therefore directed to produce the details of the amount. Interim order shall continue till next date of hearing. You say we are conscious of the fact that against order date impugned in this petition and appeal lies under section 18 of the act. However, facts are this thing and therefore we did.
Public.
And in this matter, I am appearing for respond number 2 and 3. Petitioner failed to appear in this examination hall.
Failed to appear. End of the matter.
Lordship may be permitted to withdraw the petition.
The 13% submits that in pursuance of the liberty dated 4/7/2023. No, in pursuance of the liberty dated 4/7/2023 permitting the petitioner to appear in the examination for recruitment to the post of district judge. What we don't know. I ask them.
Mr. Amir, what is the liberty you want?
We would like to file one more petition, Lordship, in a.
But once you withdraw the petition in respect of same cause of action, you cannot file another writ petition. Do you get it?
I want to specifically challenge the rule 33 of states, 23, Lordship.
So with liberty to challenge rule 33 of what rules? That you should,
Telangana.
other is pointing out on your behalf. What you are walking away? Telangana?
State Judicial Service Rules, cadre rules for 23, Lordship.
The writ petition is therefore dismissed as withdrawn with liberty as aforesaid.
Please, your lordships.
Including process getting some so, Madam 33 to 48. 33 to 48. They have written facts somewhere. Facts. Yes, item 33, Madam.
33. Lord, my submission is, my lord, the petitioner, the present case is, my lord, the petitioner has continuously resided in Telangana, my lord, till the eligibility exam was given, my lord. Petitioner gave a representation to the respondent number 2 with regard to her residential status immediately when the provisional list was issued. They have not considered the application and now they have filed a counter in the writ petition, my lord, filed by me. Even there, they have not reverted to the facts raised by me. It is clear non-application of mine by the respondent number 2, my lord. My case is, my lord,
No, no, your case is that you have challenged rule 3 of GOMS.
I am not challenging the rules. I am entitled for being considered as local as per the rules.
1 minute.
Is my case, my lord.
Yes, 1 minute. So like, yes.
Your lordship may
1
kindly.
minute. Prayer clause. Where is
Yes.
prayer? Please to issue listing non-local competent. So now there is no question of deciding your representation. They have already taken a stand.
My lord,
Right.
not mind is my in the counter also. I have stated that I have.
No, so do you want them? Do you want a direction to consider your representation? Or
My lord, that may not be relevant at this point of time. The cases.
no, no. Why, madam?
Yes.
Why we are saying so? Because this is the prayer grievance, not deciding representation. You please come to page 11. This is one of the prayers. That's why we are asking you. It's not that we don't want to decide. We will decide. Yes. So.
As per the provisional guidelines and regulations, she is entitled subsequently also, my lord. The prayer we have sought. As per the regulations, she is entitled.
You want adjudication of your status as a local person.
Yes.
Right? In this petition and no longer are pressing the relief of representation.
Yes, my lord. Because we are at a stage where the counseling has already commenced. They are going to release the list of the candidates, my lord.
Not released. There is an interim order in your favor. Huh?
There is no interim order.
There is no interim order, my lord. Your lordship has they have given an under.
Was. Then, so what are the, you are arguing on facts, madam. So which is the rule, please?
Yes,
so, so then there is no question of bunch. Each case has to be decided. So you are not challenging rule, this thing. You are saying that you are a local candidate.
Yes, ma'am.
So please tell us which.
Your lordship may kindly. Yes. Yes. Yes.
Always listen to the court because what we write matters. We have been telling repeatedly. What you speak doesn't. So please, I mean, to help us understand faster and decide your case quicker, right? You want decision right away, no? Then you must tell us which provision defines local candidate, which page. First of all,
the regulations regarding
which page?
Page 36, your lordship may take, my lord. The relevant portion.
Just a minute. You answer the query and you will find that this thing, the issue is resolved. You only answer the query of the court.
Yes.
Then if you have anything else to argue, you can argue.
Yes.
So these are eligibility
Page
conditions.
36.
Who has issued these eligibility
Come with the
conditions?
prospectus, my lord, which starts from page.
No, no,
30.
it is issued by university.
Yes.
Yes.
Statutory force.
But the rules were issued for, under the rules,
We want to know it says statutory force.
According to, yes, my lord.
Page 68, page 68.
No, no, this page 36 says a statutory force, not a statute.
But they are issued on the basis of the presidential order as per the rules also.
No, no, these eligibility conditions have a statutory
condition.
force. No, no.
But as
Please tell us.
but eligibility criteria has been incorporated in the
You can come to us a little later. Issued by university, right?
Yes, sir.
Which condition, madam? Local candidate.
Yes, my lord, page 36. Your lordship may kindly go to the next page. 3.3 deals with local area.
Local area.
Now, I would like to read 3.4, 1, my lord.
No, you read 3.3 also. You are, why you are referring to which you don't want to read?
My lord, it starts from 3.3, my lord, relating to local area. Your lordship may kindly go to 3.4.1. A candidate for admission, shall I read, my lord? A candidate for admission shall be regarded as.
What? Yes.
A candidate for admission shall be regarded as a local candidate in relation to a local area if he or she studied in the educational institution or institutions in such local area for a period not less than 4 consecutive academic years, ending with academic year in the year in which he or she appeared. This does not apply for me. Now your lordship may go to the next. Where
Which clause you fall?
it is or.
You fall under clause 2.
Yes, Lord, I'll come to that.
That's what you before reading you can tell us that I fall under.
I fall under 4.2 subclause 2, my lord. Bottom, the last one.
4.1 clause 2 you don't fall.
My lord, if I'm not falling under 3.41, I fall under 3.42, my lord. Where during the whole year,
4.2.
where during the whole year or any part of the 4 consecutive academic year ending with the academic year in which he or she appeared, or as the case may be, first appeared for relevant qualifying examination, he or she has not studied in educational institution. If he or she had resided is the important portion, my lord, in the local area for a period not less than 4 years, immediately preceding to the date of commencement of relevant qualifying examination in which he or she appeared, as the case may be.
Yeah.
Now your lordship may go to again or, my lord. 3.4.2. I will not trouble your lordship by reading subclause 1, my lord. Your lordship may go to 2.
No, read on behalf of everyone. Several other cases we will not read these clauses again.
Yes,
these people will make submissions 1, 2 and conclude in 5 minutes, right?
I'll read. A candidate who is not regarded as local candidate under subregulation 3.4.1 above in relation to any local area shall.
The normal practice is, madam, that in a batch, if senior counsels are appearing, they have a right of first audience and they are sitting quietly. I don't know. So the presumption is then each case is different, right? Mr. Rao.
All cases are one and same, Lord.
One
and same.
Senior counsels have considered the right to her in her favor. Please, lighter vein, madam. Don't be under pressure, right? We are hearing you. The senior counsels have given the preference to woman lawyer. They have given, see.
It is so, I thank everybody.
That's why they are sitting quietly and hearing you. Yes, please. Then
only submission.
3.4.2.
Senior counsel is leading the case. I
No.
do not have any objection. The only thing is
You can state. Please go ahead.
yes, no. Facts of the case.
3.4.2.
If he or she has studied in educational institution in state for a period not less than.
No. Is it correct that your case is that you fall under clause 3.4.2?
Yes. Yes, Mila.
Read that.
I read that clause, Mila. If during the whole or any part of the 7 consecutive academic years, ending with academic year in which he or she appeared, or as the case may be, first appeared for relevant qualifying examination, he or she has not studied in the educational institution in any local area, but he or she has resided in the state during the whole of the set period of the years regarded.
One. Set period means this period. Over the set period is 7 years. 7 consecutive academic years, correct? Yes. Or 7 years. So if she academic studies, first thing is she has to if during training with academy which you appeared for, which is will be first appeared for. In seven academic years, if she was first appeared in relevant qualifying examination, even if she has not studied in any local area, but she has resided in 7 consecutive academic years in the state. Yeah, this is the back. 2020. So that's been 7 years. 2.16. So out of 7 years. So, madam, so like this case put simply is that since you have resided in the state for an academic session 2016-17 to 23-24, therefore, 23-24, therefore you are entitled to be regarded as a local candidate. Are we correct in understanding your submission, or it requires some clarification?
It requires a clarification. There is a, Milord.
That's how you should better formulate your point.
Yes,
that this is what I want to say.
I understand, Milord. Now, your lordship, as I said, Milord.
So what is, what,
they have
now,
recited
1
is
minute.
of-
So what according to you, clause 3.4.22 provides according to you?
It provides that he or she has resided in the state, living state during the whole of the said period of 7 years. Here is a case of the petitioner who has resided in the state for 7 years, and the revenue authorities have also issued in as per the requirement of
No, period means not according to your choice, said period. Said period, just a minute. Said period according to our understanding and subject to what he argues refers to 7 consecutive academic years.
Disagree with that, Milord. Only thing what they say is, I will make my submissions, Milord. There is a small clarification required. The petitioner has stayed in the state of Telangana.
No. What does this rule 3, again, the same question, according to you say, what does it mean?
It means that even if they have not studied, they should have resided in the previous
7 consecutive years.
Yes.
Correct.
That
That's
is
what
my
we are also saying.
Yes.
So that's why we put it that supposing if you have resided for 7 academic years, consecutive academic years in state of Telangana,
Yes, ma'am.
you are entitled
Yes.
to be treated as local candidate.
Yes. ma'am.
Correct.
Yes. ma'am.
This the case.
Yes. ma'am.
Anything else?
In support of this, factually also, Milord, the petitioner has filed all the documents.
No, you said they are not disputing. If they are disputing, then we go to documents.
In the counter, they have not stated anything. They have adopted the counter of the next writ petition, Milord. In my counter, I have specifically stated that petitioner resided in Hyderabad. All supporting documents were filed. They have not raised any objection for that. So I take it as admit, Milord.
Huh? What are the documents to show that for 7 consecutive academic years you have stated in Telangana residing?
I'll come.
This what you should have done.
Now,
Madam Chart,
Quickly.
you should have done this what?
quickly, I will take your lordship's, Milord.
Get a chart on these facts, right? We are not required to note down this certificate issued by this authority, this page.
Milord,
Ask your colleagues to have a working lunch. They always have a working lunch, or maybe to skip lunch today. And have this.
Milord,
Yes.
Milord. Now, your lordship may kindly go to page 24.
You have challenged the rules, right, in your petitions, Mr. Regulation, right? No, we're just asking. So there are two, Mr. Rao, there are 2 types of cases where the rules have not been challenged and where rules are challenged.
We are challenging the regulations.
Regulation.
The rules under which they are made.
No. So where Mr. Rao can give us some cases where, like Madam's case, nothing is challenged and. No. We are asking you which cases, like Madam, rules or regulation have not been challenged. Only her case. All.
Yeah, I'm not challenging.
Which case?
37, item number 37.
Huh?
Item number 37.
Okay.
38 also, Lordship, may permit me, sir.
I'm
38.
saying
Yes, we will hear you then. 38 and which other case?
This is 38.
That's it.
38, Lordship.
Yes, Madam.
Milord, I'll just take very little time, Milord. Your lordship may kindly take page 24, Milord. Page 24 is the mark certificate of the student showing that she has completed her 10th class from DPS.
Will you give us a chart saying this chart? Handwritten also will do. these certificates, this prove this, that she has resided, instead of we turning pages.
Yes, my lord. I have.
Will you give it after the break?
Yes,
You
I'll-
prepare this
I'll give
thing.
it.
So
I'll-
these documents prove that in the, this petitioner is residing for 7 consecutive academic years in the state of Telangana. 1, 2, 3, 4, 5, 6 pages number dash dash dash.
Yes.
Right. So, and this your submission is, these documents have not been denied by this thing in the counter.
Yes, my lord. Yes. Only one twist is, my lord, during the COVID, the petitioner's father,
Just a minute.
they have seen only.
1 minute. 1 minute. We are writing it down. That's why. Very difficult, madam, to, we have to record your submission also, no? I wish that we could have done a shorthand thing, which you can avoid by giving synopsis, you don't do. So we have to write everything. Then you will say that I had argued this, court did not write. So that's why we are writing. 7 petitioner resided in 7 consecutive academic year in state of Telangana, not denied in the counter. Yes, what else?
Lord.
So you have, this is your specific case which has not been denied by the, this thing then. Fine.
And they have gone through only one certificate, which is at page 23, my lord. That is the intermediate, that is 12th class.
That's why,
Yes, my lord.
that's why what we said, that you please give us this all factual thing.
Yes.
That where this, you should assist us with the chart and written if you are unable to get it typed.
Based on
This
this
is
certificate.
Kota, Rajasthan.
Yes, my lord. Only this observation they have rejected, my lord. They have not considered other documents.
Yes.
They, based on only this document, I understand, because I have not given any counter nor.
He will tell us.
I understand they have rejected. My case is, my lord, the petitioner's father, who is a scientist in the one of the ICAR, my lord, anticipating transfer, he took admission for his daughter much before completion of 10th standard exams in Kota, Rajasthan, my lord. Pending, when the petitioner was giving her exams for.
Kota is famous for MBBS also, right, madam? It's only IIT.
Kota is for CA. CA. It is very famous for CA. Kota, Rajasthan is IIT, 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 CA.
And MBBS also, she went on. MBBS also it is known Kota, Rajasthan. Okay. So, no, so you went to Kota, right?
No, petitioner didn't go. That is my submission.
Then how this CBSE thing?
I will take my submission. Your lordship may just give me few minutes, my lord. Then I leave it to your lordship, my lord. Took admission in Kota, Rajasthan when she was writing her 10th standard exams.
Where are these facts pleaded, madam?
I have stated.
Which paragraph of the petition tell us?
My affidavit, my lord.
Which paragraph?
Yes, my lord.
No, so you did not pass the examination for Kota, this certificate is wrong.
My lord, if your lordship permits me, I may.
Of course. We are only,
Then your
madam,
lordship may.
again, that council we told, the purpose of putting question is to understand what is traveling, what is going on in our mind.
Yes.
You just left, left like a mystery. 23 is Kota against me, but you are not saying thereafter. So we are asking, what does it mean?
My lord,
And you are
I'm ready, my lord.
first say that this is what they have denied. This is not incorrect for this reason. Then we will appreciate. You have referred to 23 and left it at that. Please.
I'm continuing. Petitioner's father.
Simple answer is one sentence, madam. We will tell you. The petitioner continued to attend online classes in the due to pandemic this thing, but was residing in Telangana is the simple answer.
But I don't want to leave a stone unturned, my lord.
No, so we have.
I want to press.
Other as in the meanwhile, find out for you what you want to argue. This whole anxiety, madam, is to save time. Nothing that we can continue listening to you. Relax 4:30 and tell everybody that please go home. They would like to do it. The anxiety is only to conclude.
Yes.
Brother has found out the your case, what you are going to contend.
Yes.
You are not telling we found out that she attended online classes and was residing in Telangana.
And she has given her exams. Your lordship may kindly go to the next page, my lord. She has given her board exams from.
Correct. So this is your point, right?
She never went to Kota, Rajasthan, my lord. She gave her board exams from Hyderabad. She appeared for.
Oh, Mr.
Appeared
Ever met 1 minute. That's it. Anything else?
For the exams of entrance exam twice, my lord. Both the time she has given her exams from Hyderabad, in support of which I have filed the hall tickets, my lord. And the petitioner's father never left Hyderabad as he was not transferred. So continuously the petitioner is residing in Hyderabad only. Even the parents.
Give a handwritten note on the documents showing her academic this thing.
And
anything else?
the respondent counsel has placed the full bench judgment. The other day when the matter came up for admission, my lord, my submission is, my lord, in the full bench judgment, the point which I
You will have a right to rejoinder. He is still to argue, Mr. Rao. Let him cite full bench, then you can say that it does not apply. Acha, what you are saying full bench does not apply?
has not considered this case, my lord.
Obviously can't consider.
There's a special
Case is unique case, right? It is you have come to court for the first time in 23, so full bench could not have considered your case.
COVID situation also was not there, my lord.
There.
The petitioner has taken the COVID vaccine here and she underwent operation for thyroid in Hyderabad. I have not filed those documents. Necessary, I will file those also.
We don't know.
That may not be necessary because I have filed sufficient.
So 3.4, 2. Roman 2 not considered in full bench.
Yes.
Correct.
Yes, ma'am. With regard to resident.
Correct.
That is more.
Madam, your case doesn't lay down any law. Like we on facts we have to decide whether or not she is this local person or whatever person.
Yes.
Mr. Rao, what happens to this thing? Our case you have understood is now we will put it to you so that you can answer. Our case is that she falls under clause 3.4 Roman 2 and 3.4.2 within bracket Roman 2, small Roman 2. Then this thing is that I have specifically pleaded that petitioner has resided in 7 consecutive academic years in the state of Telangana, and this fact is not denied. You have merely by placing lens on this quota thing, you have rejected. And in para 3, specific averment has been made that she attended classes online and did not go to Rajasthan and took vaccination also in Telangana, and appeared twice from Telangana. So the problem is, you will have to answer this. In the absence of any denial on behalf of any of you to averments made in paragraph 3, at this point of time, there is nothing to hold that she didn't do online and went to Kota. This is a fact-finding inquiry. Which certificate? This is
CBSE hall ticket.
Page 23, Lord. Page 23. But senior school certificate examination, page 23, Lord.
Go to page 22.
26 lakhs. 22.
You said 22, right?
22 is the examination hall ticket.
Yes, Lord.
So this is in respect of a college where she joined for 11th and 12th standard, which is located in Kota, Rajasthan. But exam is held. Please look at the exam center.
Yes, Lord.
Hyderabad.
Yes, sir.
So the question of a student requiring to go to Kota, be there and write exam is not necessary. Therefore, somebody can be in Hyderabad and write to seek an admission in a institute in Kota and write exam from here is permitted.
Yes, Lord.
And the fact that she has written in Hyderabad is also evident from this.
Yes, sir.
And so far as the writing examination is from Hyderabad. Now, last may kindly see page 23, my lord. My lord, intermediate
So,
contain.
Mr. Rao, what is your submission? So
My
that we
submission
can,
lordship says.
number one.
Practicals will be there, my lord, in a science. Biology, physics, chemistry.
No, but see, Mr.
Online.
No, Mr. Rao, perhaps you would appreciate that again back to square one, specific case pleaded in para 3, which is not denied by anyone. What is the ever consequences in law, you understand?
Well, by submission, yes, Lord. I understand. I understand, my lord. The fact remains is
One of the courses, I mean, we don't know, we are just wondering whether you should at your level examine this factual dispute that whether or not she had gone there, conduct an inquiry, take into account COVID times, people were doing online thing, all this and come to a conclusion. Until then, don't declare result. Another option is we pass an order. Third option is you file specific counter.
well, I will file counter by Monday, my lord.
Monday.
Monday.
Madam, no, only thing you are required to do is that chart thing.
I'll do it.
Learn it.
Appointment, your
One minute.
lordship, just
Nothing.
Page.
It is being, he is filing a specific counter, you make a chart.
Yes.
Don't this thing. In this writ petition, comma, mark the presence. In this writ petition, comma, the petitioner, in this writ petition, comma, the petitioner inter alia seeks a direction to the Tuesday, Mr. Rao. Tuesday. It's understood that you will not do anything till Tuesday. No, so, but what do we, like, you want time to file a counter to this. Otherwise, if you, in the absence of any counter, this averment shall be taken to be admitted. Principles of Order 8, Rule 5 apply to writ petition also. That's why.
But I'll file counsel on Monday.
One thing is, don't hold everything. They keep one seat vacant. You say that one seat shall not be filled up till whatever date.
Yes.
That will suffice.
Lords may put it on Monday, my lord. I will do it.
Monday?
Tuesday.
Tuesday. So in the meanwhile, we will say one seat.
One seat, yes.
1 minute.
Similar order has no application. Similar order has no application.
No.
But only this, yes.
This case, he is saying. You are saying, or we direct?
Your last
Direct. All right. The place for so and so to enable him to so and so. Paragraph. Nothing happens. The classes will not start. You want permission to sit in the class.
No.
It will not close.
We are going on extending back.
No.
23rd.
We are aware about the time schedule by Supreme Court in Bridaldhar. No court can grant admission. So thereby 23rd, he knows better, Mr. Rao. Knows better. Yes. Have faith in him. He is a fair counsel. 23rd August. So which other case, Mr. Rao, which other case will you say, or each case?
Similar, like.
This is item 33.
Yes, Lord.
Which other case will you say like this?
The other cases are different, Lord. You have to argue.
So individually we have to examine,
Yes,
right?
yes.
Okay. So this is only exception. The first case only an exception.
But then Lord, 230.
Exception should come by way of a proviso, not main provision.
But you also taking up the.
Item number 37 is also.
Matters are taking 230.
So what to do, Mr. Rao, one matter we have fixed where.
After 84 Lord, batch 5 cases, then Lord, these cases will be taken.
Continue. So there is one, Mr. Senior Counsel, there is, Advocate General has made a mention at 10:30. He said that there is urgency in another batch. So that we will hear from 2:30 onwards. And we hope that it will be concluded. After that, we proceed from serial number 34 onwards. Madam, synopsis, this.
Yes,
all
I will make the synopsis.
where 7 academic years, which document, which place produce, so that saves time. call that 80 bunch. Advocate General.
Item 84 to 89. Group of, Ravi Kumar,
My lord, sir, my friends, the petitioners may submit. Your lordship may hear the petitioners, my lord. A
short list of pages. I request your lordships to
1 minute. So she has been permitted to indicate her web option. Mr. Advocate General.
Yes.
All right. So, Mr. Your case is that you are not a resident of Telangana. Your claim for admission is against the seats in medical colleges which have been set up after bifurcation of the state. Correct?
just a,
Like 85% of the seats under the competent authority quota have been reserved for local candidates, that is students of Telangana. You come under 15% of the seats earmarked for local as well as non-local, being a non-local. Your claim, but your claim is being confined in respect of colleges which have been set up. Colleges which were set up prior to bifurcation of state and not in respect of medical colleges which have been set up after bifurcation of the state.
my grievance, your lordships, is
Correct.
that the 15%.
No, correct or not?
That's a small modification, your lordships.
This is what is recorded in the, you are Anup Kaushik.
Yes, your lordships.
Then in your presence, this order has been recorded.
15% in the colleges that have been established subsequent to 2014.
That's what we are saying.
Obliged. That's it, your lordships.
After bifurcation of the state. That's what we are saying.
Yes, your lord.
Same thing.
Yes, your lordship.
It can't be, once it goes into this order sheet, it can't be wrong.
Yes, your lordship.
We ensure that it is correct. 1 minute. Now we will straightway come to your submissions. In 2 minutes time, let us go through what you have prepared.
Obliged.
Student completed, NEET, secured. You are the counsel in all the cases?
Yes, your lordships. Not on all the cases, your lordships. I am the counsel for item 84, 85 and 87.
84, 85
and 87.
And others are different, right?
89.
88. They are same, right?
Yes, the same principle.
Yes.
Okay. So let him formulate his submission. If you have any additional, please be precise. That is the purpose of this exercise. We want to show how effectively and within no time it can be adjudicated, provided all of you cooperate. Wait.
No, my only request, your lordships, along with that list of dates, I request your lordships to have a look at the memo that I have gotten filed. I have consolidated all the legal documents, the case laws and the...
There are no illegal documents. All are legal documents.
Beyond pleadings. That's what I meant, your lordships.
Why you have given us this? This of no use.
These are the
list of dates.
Yes, your lordship.
Please permit us to go through it. That's the idea. If you keep on arguing after handing over, what's the use?
Obliged.
You have written it and it's correct, right? Not incorrect submissions. We will ask Advocate General what is it. You have challenged the validity of the rule?
I've challenged the validity of the government order, the amendment to the rule, your lordships.
Rule, right?
Yes, your lordships.
Which provides that in colleges established after 2nd June 2014, 100% of competent authority quota are reserved for local candidates.
Yes, your lordships.
So the question involved is whether 100% reservation on the basis of residence can be prescribed.
Yes, your lordships.
What ground you are assailing this provision? Number 1.
The issue, your lordships, is basically the law flows from your lordships, Article 371D.
No, first proposition.
Proposition, your
1,
lordships.
2, 3. What? How many grounds you are challenging this rule?
2 grounds, your lordships. First ground, your lordships, is that the government order is contra to the presidential order.
Government order dated
Government order dated
3/7/23.
Yes, your lordships.
Amending, adding a new provision.
Adding a new rule H.
3(2)H.
Yes, your lordship.
Contrary to presidential.
To the pre-existing government order.
Presidential order. What? Which clause? Everything whole, or any particular clause?
Presidential order, your lordships, 1974. Presidential order 1974.
Whole
The entire the presidential order deals with the distribution of seats in relation to educational institutions.
So, in particular, any clause or whole of it? How many clauses are there in presidential order? Say, supposing 25. So, your case is that it is government order is contrary to all clauses 25, right?
No, your lordships.
Then that's the what specific thing, Mr.
Rule 7.
Clause 7.
Clause 7.
All. Second submission. Second, come.
Lordships.
First you have told, second.
Second, your lordship, says that as per section 95 of the Bifurcation Act.
Reorganization Act.
Lordships.
It's a Reorganization Act, not Bifurcation.
My apologies. AP Reorganization Act. As per section 95 of AP Reorganization Act.
2000?
2014, your lordship.
14. Yes.
The quota, whatever was existing as on date bifurcation, must continue for a period of 10 years and can't be altered.
What is the date of bifurcation?
2014, your lordship. 2nd June 2014.
Has to be maintained for
period of 10 years.
Years.
These are the two main grounds, your lordships.
No. So you want to say that in light of section 95 of the AP Reorganization Act, the legislature has no power even to, don't, we told you that day also, you are not Swami Vivekananda. The moment we are trying to understand, Mr. You have put it very well. We are trying to understand that you want to say that in view of section 95 of the AP Reorganization Act, the state has no power to amend the rules for 10 years.
That's what I suppose.
Legislative power to amend the rule is suspended.
Legislative authority to amend the rules could be carried forward. However, the split of seat allocation
it
cannot be
amended,
modified.
Except for
seat allocation.
No, so
seat sharing ratio maybe.
1 minute. So quota existing on date of bifurcation, how how they have altered by amending the rule?
The submission, your lordship.
Yes, yes. Now we will, you first now elaborate on first submission.
Greatly obliged.
Yes.
Just to put
Where is the rule 32H first? Which page?
page 23 is the impugned order, your lordships.
23.
The last paragraph on the page, your lordships.
Page
In
23.
colleges established.
Verification statement.
Page 23.
20880, Mr.
18,047.
This is also your case. 20880 you tell. We go by item.
8047 will find counter. That is the next case.
18047, they've filed a counter, your lordships.
In that interim order, therefore it's out.
18047. How did it go? On the sheet here in this case. Yes. Page
23, your lordship.
So therefore you must tell the court which you are referring to, which petition.
Item 84, your lordships. That's. They seem
Next
to have
time.
handed
Next
over
time.
83.
This thing is a learning process, right? For us as well as you. So now
Obliged.
you remember that before referring to, you should tell I am referring to WP so and so.
Obliged.
Records of WP so and so. 32H.
In colleges established after 2nd June 2014, 100% of seats under competent authority quota are reserved for local candidates and all applicable reservations shall be implemented.
But what is 32?
The pre-existing, your lordships, is page 62. Page 61 is the pre-existing rules would start. The relevant amendment, your lordship, has been added on page 63. After subclause G, H has been added. Reservations, the capital Roman number 2.
Oh, what? Yes.
Clause D and E have also been amended, your lordships, through the impugned order. I am not as such challenging these two clauses. However, a reading of D and E would kind of put in perspective my entire argument. With your permissions, I'll just read clause D and E. Clause D and E on page 63. 85% of seats, page 63, your lordships, subclause D. 85% of seats are reserved for local candidates in non-statewide institutions. 15% of seats are treated as unreserved seats. 15% seats, clause E, your lordships. 15% seats shall be unreserved in each college, and reservation shall be maintained as far as possible for unreserved seats on total seats available. Your lordships, the pre-existing context is out of 100 seats in each college, 15 seats are for local and non-local, 85% seats are for local. period. Now, your lordships, this 15%, the issue arises like this. Clause H as being introduced reads, there are two interpretations that would come forward from reading of this clause. In colleges established after 2nd June 2014, 100% seats.
No, so Mr. 15% seats continue to be reserved for local as well as non-local. Clause F only says that in respect of an institution, college established on after 2nd June, all seats are reserved for domicile, while for locals and non-locals have been denied admission, excluded.
That is all.
That is
that is all.
So, so
that's where the problem starts.
No. So all right, we have understood now why it is contrary to clause 7 of presidential order.
Your lordships, I am taking your lordships to. Article 371D, your lordships, at page 91. Special provisions with respect to
page
91, your lordships. Special provisions with respect to the state of Andhra Pradesh or the state of Telangana. The president may, by order made with respect to the state of Andhra Pradesh or the state of Telangana, provide having regard to the requirement of each state for equitable opportunities and facilitates for the people belonging to different parts of such state in the matter of public employment and in the matter of education, and different provisions may be made for various parts of the states. Of this, your lordships, on page 92, Article 391D, clause C, subclause 2. On page 92, subclause 2, in the matter of admission to any university or other educational institutions, refer to in subclause B, as may be specified in this behalf in the order. Clause C, specify the extent to which, the manner in which, and the conditions subject to which preference or reservation shall be given or made in the matter of admission to any such university or other educational institution referred to in subclause B, as may be so and so. This is the provision of article, your lordships, which gives the authorization for the president to issue a special presidential orders with respect to these two states. Now, your lordships, I would request your lordships to look at the memo that I have gotten filed in this writ petition.
You should read last 3-4 lines also. To or in favor of candidates who have resided in, it's not like local area. After clause 31D(c) Roman 2, you stopped as the case may be, behalf in the order, right? Thereafter read these 3 lines.
To or in favor of candidates who have resided or studied for any period specified in the order in the local area in respect of such cadre, university or other educational institution as the case may be.
Yes.
Lordships, I'll request your lordships attention to the presidential order.
Yes. Then
Lordships, the memo that I have filed, your lordships, for the presidential.
What is it?
That is where I have filed the presidential order, your lordships.
Madam.
The government order along which the presidential order is annexed. I could not.
Yes.
The government order that has been issued.
Which page?
Page 1, your lordships. Start with. This is the government order that has been issued, your lordships, by the government of Andhra Pradesh, along with the at annexure 3 on page 9 of this memo. The presidential order has been annexed. Just to put things in perspective, your lordships, I'll just read the first para of the government order before I take your lordships.
Whether after bifurcation this memo, the order still exists or it is repealed or something?
Presidential order is sustaining, your lordships. Just to give the context of the presidential order, I'm just reading the first paragraph of this order. In exercise of powers conferred by clauses 1 and 2 of Articles 371D of the Constitution of India, the President has made, with respect to the state of Andhra Pradesh, the Andhra Pradesh Educational Institutions Regulation of Admissions Order 1974. This presidential order was published at pages so and so of Gazette of India Extraordinary, Part 2 so and so. The order was republished in Andhra Pradesh Gazette order first read above. A copy of the order as amended up to date is appended. Appended, your lordships, is at annexure 3 on page 9.
Clause 7.
Procedure for
Yes.
annexure 3, your lordships, on page 9. Procedure for implementation of reservation in favor of local candidates provided under Andhra Pradesh educational institutions in respect of non-statewide universities and other non-statewide educational institutions. Clause 1, your lordships, the number of available seats in the course of study shall first be computed by deducting from the total number of seats provided in that course the number of seats reserved for candidates from outside the state. The number of seats reserved in favor of local candidates in relation to the local area in respect of the university or other educational institutions concerned shall then be determined. This number shall be 85% of the available seats. Any fraction of the seat being counted as one provided, there shall be at least one unreserved seat. So, your lordships, the local reservation is restricted to 85%. Now, how this
proceed?
How this 85% is to be appropriated among the locals is
See, all your colleagues are watching you intently. So supposing if they feel that you have made out a point, then they will say that my case is similar to that. Otherwise, they will say, no, our case is not covered. It's different.
I just hope I don't spoil anyone's case.
No, you should not this thing. They are watching keenly. Yes. Yes.
So your lordships, this the 85% is what is reserved for the locals, and that apportionment of this 85% how to be done is given further in this presidential order. Now 15% is the unreserved category, is what submission is.
No, you are, Mr. You are happy with 15% for local and non-local, but your grievance is only in respect of this thing, institution established in the state of Telangana after bifurcation, insofar as it excludes you, right?
Yes, your lordships.
So that is what? That is arbitrary.
Yes, your lordship. Therefore, your lordship, once I establish that the local is restricted to 85% and the 15 is supposed to be open for both local and non-local, once this court is convinced that 15% is for local and non-local, then your lordship.
What the rule is. That's what the rule.
That's what the rule is. So now that I have drawn your lordship's point to that 85% is for local and 15% is for unreserved. Now my only contention, your lordships, is as per the impugned GO clause H, they say that 85%, sorry, 100% of seats under competent authority quota are reserved for local candidates, and all applicable reservations shall be implemented. Now, here, your lordships, competent authority quota, as per the learned counsels for respondents, would be that 85% is what must be considered as competent authority quota.
No, you don't feel distracted by the, you have demonstrated that according to you, this is violative of presidential order, right? Second is section 95 of Reorganization Act.
Section 95, your lordships, I'll take your lordships to section 95. Page 90 of my writ petition, your lordships. Section 95 on page 90. Access to higher education. In order to ensure equal opportunities for equality, higher education to all students in the successor states, the existing admission quotas in all government, private, aided, unaided institutions of higher, technical and medical education, insofar as it is provided under Article 371D of the Constitution, shall continue as such for a period of 10 years, during which the existing common admission process shall continue. This being so, your lordships, our contention is that whatever was pre-existing on 2nd June 2014 must continue till 2nd June 2024. And
44, 24.
24, your lordships, 24. By the reading of both the presidential order as well as my section 95 of Reorganization Act, our contention is the date of establishment of these institutions would have no role. Rather, as long as it is an institution in the state that is offering higher education, then the ratio that must
be date of bifurcation
2nd June 2014. So the date of establishment of the institution would have no bearing on the seat ratio that is supposed to be offered, is our submission.
This act came into force when? This what, which year?
2014, Your Lordship.
Okay.
The clause H.
This provision would cover according to us 95 would cover and would apply to existing institution only, not the institution which may be created thereafter, right? Because ordinary this thing parlance.
There is no distinct, my submission, Your Lordship. If I may read the article again for my.
Yes.
In order to ensure equal opportunities of quality higher education.
Section 95, not article.
Section 95.
Yes.
In order to ensure equal opportunities for quality higher education to all students in the successor states, the existing admission quota in all government, private, aided or unaided institutions of higher technical and medical education, insofar as it is provided under Article 371D. 371D does not choose the date 2nd June 2014. The existing admission quotas will continue in all the colleges as is contemplated under 371D. So the date of bifurcation is not the context of either this section or 371D.
So it is violative according to you of section 95.
95 and as well as the presidential order.
And anything else?
Just to demonstrate the violation, Your Lordships, in the same memo.
No, we are surprised you are not saying that reservation cannot be provided in any case to the extent of 100%.
Obliged.
Obliged?
That
it's not our case, right?
That is of course the case, Your Lordship.
Huh? No, what we are saying is we are not petitioners, right? We don't want admission institution after 1640. You are not saying that even assuming everything to be in favor of state, 100% can't be prescribed.
Yes, Your Lordship.
Alternative submission.
Yes, Your Lordship. I was coming to that after demonstrating as to what.
What demonstrating? We asked you initially, you said only 2 grounds.
Lordships. The alternative submission was that, Your Lordships.
Say so.
Page 113 of the memo, Your Lordships. This is the admission notification.
What is your position like in merit list?
I have stated my position, Your
No, we are asking just.
I have a rank, Your Lordships.
Okay.
I'm a rank holder and I'm entitled for exercising my options. I have stated so in the affidavit.
That's it. Anything else?
The seat matrix that has been published by the government goes in line with the order, wherein, Your Lordships, in the colleges that have been established prior to 2nd June 2014, they give the category of seat bifurcation for local and unreserved. Whereas with reference to the colleges that have been established subsequent to 2nd June 2014, the very category of unreserved has been removed, thereby showing that the entire extent of seats in those colleges are for locals only. Therefore, Your Lordships, our submission that it is violated.
Case law. Nothing. No case law.
Case law, your lordships, in the same memo, your lordships, I have given the proposition notes. Validity of the presidential order upheld, the ratio of the local seat sharing and the memo, your lordships.
18047.
Yes, your lordships, the memo. The first page, the index. I have put forward two propositions, your lordships. One, the validity of the presidential order upheld, the ratio of the local seat sharing and 15% of unreserved candidates is affirmed through these judgments. And the second proposition I relied upon, your lordships, is that the rules
will be answered by Constitution Bench of Honorable Supreme Court whether rules of game can be changed or not. This is not the proposition you have argued. Mr. You made two submissions, right?
Yes, your lordship.
And we added the third facet to it.
Yes, your
You should have said 100% reservation cannot be this thing provided. What decision, which decision you should have relied upon? You are saying rules of the game. Nobody is changing rules of the game.
The fact of removing the seats, availability of seats being reduced is also a change in the.
Amending the rule doesn't mean that rules of the game are being changed.
The rule has been amended subsequent to the
all right
entrance exam.
But you have not argued this proposition and giving case laws. That's all what we are saying, that this all is not relevant, Mr. You have not raised this proposition. Three grounds you have raised. This rule game, this thing is not changed. No submission made, therefore not necessary to examine SCC online Kerala 2419. That's what we are saying. And this is a fact. Validity of presidential order upheld. What you should have cited is 100% reservation cannot be prescribed. You are silent of that, leaving the court to find out. Huh? Yes, that's it.
That's it.
Anybody else on behalf petition?
86, my lord.
Adopting submissions 3.
Yes, I'll just.
In addition, any
addition.
number 4. What is it? You tell submission, Mr.
Yes.
We have heard him, everything, read it.
Taking a cue from your lordships, my lord, 100% reservation. The state cannot, my lord.
That is already.
Yes, yes.
Fine.
To support that, my lord.
Which decision?
Pradeep Jain's case, my lord. Pradeep Jain and others versus Union of India, reported in 1984 3 SEC 654, my lord.
So this is 84 decision. It has been considered several times by Supreme Court.
Yes, yes.
What is the latest treatment of this case by Supreme Court?
Yes, in the Jharkhand case, my lord, last year, teachers, my lord, then this is exactly
which Jharkhand case. This 84 3 SCC has not been reversed. It is a good law.
Yes.
Pradeep Jain.
Yes. Court of. Just read one paragraph, my lord. This is in the context where.
No, what? Pradeep Jain.
Yes, Pradeep
Which
Jain.
para?
Paragraph 20, my lord.
20.
In fact, this supports the state for providing majority of the reservation in favor of the locals. This judgment supports the state to the extent of providing 100%, my lord.
So why are you citing then against you?
Yes, paragraph 20. Paragraph 20.
He's saying that 100% also supports.
Paragraph 20.
Yes.
At page 688. The only question which remains to be considered is as to what should be the extent of reservation based on residence requirement and institutional preference. There can be no doubt that such reservation cannot completely exclude admission of students from other.
What happened to this judgment? 84 3 SCC 654. What happened to this judgment subsequently? Must be call Rahul. Rahul Reddy. Lochner. percentage. This thing, there must be. Mr. Advocate General, whether assent of the president was obtained before incorporating rule 32H.
My lords, no. My lords, I will.
I mean, we are just, you answer this when you.
Yes.
This the query we have.
Yes.
Please note it down.
Yes.
Answer. So?
My lord.
No. So you mean to say that Pradeep Jain has never been considered by subsequent decisions of Supreme Court? You are citing as if it is a 2023 decision given in the month of July.
But these are matters dealt with under the medical admissions, my lord. There are other
This
cases,
has
my
been
lord.
considered repeatedly.
Yes, yes.
1990, I can tell you 1990 volume 2 SCC. It has been again considered 5 years later, explained.
Even our honorable High Court, my lord.
Where is that? I mean, when you cite an old judgment like 1956, then you must, you are required to explain what treatment has been given to it. You must always say that, sir, the latest view, 1923, 2023, it has been, the ratio has been followed. So it is a valid. So shall we record your statement that it is not considered anywhere and it is
consistently?
Then where is?
I'll submit.
So
Let
para
this-
20,
Yes.
Mr. This thing. Right. We have understood this proposition.
Yes.
Completely exclude the admission from other universities and states. Right. Correct.
Yes. Let 85% pertains to the
Wholesale reservation on the basis of domicile not permissible.
Yes.
Correct.
To the extent of yes.
That's anything else. Mr.
Yes, I'll just on an earlier occasion.
What else?
Yes, my lord. On an earlier occasion, there was an increase in the number of seats. In that context, my lord, this honorable High Court, my lord, 2017 1
May you tell us what happened to Pradeep Jain after 84?
Yes.
By the time we hear learned Advocate General, anything else apart from 100%?
Just to add one more.
About 84 volume 3 SCC C654 Pradeep Jain. Para 20, the law is that the reservation cannot completely write down. Reservation cannot completely exclude admission of students from other universities and states on the basis of merit judged in an open competition. Then they have said that wholesale reservation on the basis of domicile or residence requirement within the state or on the basis of institutional preference is violative of Article 14. This is the ratio. This Pradeep Jain has been considered in several cases. He is not telling us. You tell us how it has been treated subsequently. And even thereafter, 1990 volume 2 SCC, it has been considered.
Just check.
check and everything wherever and give a print, give within 10-15 minutes, we have to dictate an order, urgent matter. That's it.
Yes, Pradeep Jain's case, my lord, in the year 2022, my lord, in the case of Satyajit Kumar and others versus the state of Jharkhand, reported in 2022, live law. I'll give a copy, my lord.
Live
SC 651. Yes, I'll give a copy of SEC, my lord. This is in the context of providing 100% reservation to locals in the matter of
which case, Mr. Name?
Satyajit Kumar and others versus Satyajit Kumar and others versus the state of Jharkhand and others. To recruit teachers, my lord, 100% reservation was given to the locals in the state. Schedule.
Find out the citation. It's all available on.
Yes. My lord, to counter, my lord, the GO, look, the effect of the amendment, the GO 72, would be to restrict, my lord, the candidates who fall
You
under
have heard, right? You have heard your client is sitting behind.
No, my lord.
Sit down. You have heard your friend arguing. We have heard that all patients. Any additional submission, you are elaborating the submission, which this thing we would have put to the petitioner anyway. You have relied on 84.
I'm only supplementing, my lord.
So what?
My lord, your lordships had a doubt whether after Reorganization Act came into force, whether it would include the new institutions. To answer that, my lord, your lordships expressed a doubt that whether after 2014, after introduction of the Act, whether new institutions would be covered under and
So
section
that's why
95
you
would.
should say so.
Yes, I'm sorry.
Then we understand.
I'm sorry.
If you are saying that come to page 85, we don't get anything.
No.
The suspense continues. What 85? Then come to 43. What 43? You must say that I am trying to explain the query posed by the court that it can't apply to this thing. So we will be receptive. We are saying, we are thinking that petitioner is sitting behind, so you are arguing. Please understand, we have to decide this case also, right?
I'll just complete it. Page 70 of my writ bundle, my lord. Item.
Which bundle?
My lord, writ bundle, my 18216, my lord. I'll just take your lordships to the presidential order.
That he has referred, no?
No,
The bundle you
the definitions part, my lord. Page 70.
Page?
18216, my lord, page 70.
What?
My lord, definitions, these are interpretation in this order, available seats. But I won't cite this interpretation of this. In this order, unless the context otherwise requires, available seats in relation to any course of study means the number of seats provided in that course for admission at any time after excluding those reserved for candidates from outside the state. This would answer, my lord, application of section 95 even after, my lord, 2014, my lord.
No, so therefore in view of 21A.
Yes.
21A of this presidential order has to be read along with section 95.
Because 9 years, they were following a practice.
This is what a proposition he has, learned advocate general has to answer.
Yes.
It was just by your harping upon it as if that is the issue decided against you and you are filing an appeal against that. Let us see what he argues. Anybody else? That's it.
But in order to support this proposition, my lord, there's a decision.
Let him first argue. You will have a right of rejoinder, right? Let him first notice what he argues. If he doesn't argue, then the laboring does not arise. Question of convincing the court. Let's hear. You will have a right of rejoinder. What, Mr.
The issue involved in this writ petition squarely.
Which writ petition?
The 89, item number 89, sir. Issue involved in the writ petitions.
No, grievance is same, right?
Yes, sir. Only I will not take more than 2 minutes, ma'am.
Please. No, we want to understand that you are saying that issue involved in item 89, so we ask whether it's different.
No, Bilal. What
Not
I said,
different.
the issue already answered with Honorable Court earlier in the earlier occasions.
Ah. Ah. Yes. A similar provision was made earlier also. Quashed.
Yes, madam.
You should have told him he was arguing with all seriousness, even did not smile. You should have said, relax, I've got a judgment.
2016 SEC online Hyderabad 624 Bilal.
This 2000?
16 SEC online Hyderabad 624 Bilal. The same issue. Earlier, the Lordship may come to directly
1 minute.
to para 20 Bilal. Para 20.
1 minute, 1 minute. Three seats available for admission local, not throwing even to one of the unreserved category. Para
20.
22.
20 Bilal.
20.
The Lordship may start from 19 onwards, Bilal. Para 19.
Oh, you have to start.
Sorry,
19.
19. It's true that Article 371 as existed prior to 26/2004, there was a reference only to the state of Andhra Pradesh. But by State of Andhra Pradesh Reorganization Act 2004, the word state of Andhra Pradesh were substituted with the word state of Andhra Pradesh or state of Telangana. Therefore, the contention of the learned Advocate General, Additional Advocate, is that after the bifurcation of the state, the entire presidential order will have to be applied independently each of the two states. And there is no question of applying provisions of the presidential order combined state. Both states are exist together even as next. Theoretically, the learned Advocate General may be right in saying that after two states are formed, the provisions of the Article 371D may have to be applied independently to each of the states. But unfortunately, the second respondent university, key to the problem is found to be Section 95 of the Andhra Pradesh Reorganization Act 2014. Section 95 reads as follows. I am skipping the Section 95. Section 95, only word I'm pressing for the only words, in order to ensure equal opportunities for quality higher education to all students in successor states, the existing admission quotas, that not my submission is that not existing seats, existing quotas in all government, private, aided, unaided institutions, higher and technical medical education, insofar as the provided under Article 371D of the Constitution, shall continue to, as such, the period of 10 years during which existing common admission process shall continue. A careful look at the Section 95 would show that both the governments are obliged to maintain the existing admission quotas in all government, private, aided, unaided institutions, as provided in Article 371D of the Constitution, for a period of 10 years, during which the existing common admission process is to continue. The words and phrases that are significant in Section 95 of the Reorganization Act is all students in the successor states. That's one. And the existing admission quotas shall continue as such. The existing common admission process. Now, if all the above words, phrases carefully looked at, it could be clear that what is expected to continue for 10 years by Section 95 is existing quota under the existing common admission process. These words assume significance in the light of the fact that words in paragraph 5(1) of the presidential order are available seats. In Section 95 does not use the expression available seats. The emphasis on Section 95 is not on seats but on the existing quota. In other words, what is out to be preserved is the quota, not the number of seats. That's 23 million. The result of which, if any one or more of the two states increase the number of seats, the benefit of such increase should be made available to a period of 10 years under Section 95 to common admission process with application of the existing quota, namely 85% of the locals or 85% of the locals within the distribution pattern of the 42, 36, 22. The learned Advocate General, Additional Advocate General sought to give different interpretation to the expression existing quota by relying upon the decision of the Supreme Court in State Bank of India versus Yogendra Kumar Srivatsava. In the said case, the question that arose before the Supreme Court was whether the expression existing officers would include probationary training officers or the not. The Supreme Court held that having regard to the broad framework of the policy framed by the State Bank of India, the probationary and training officers are not to be counted existing officers. Placing reliance upon the said judgment, it was contended by the learned Additional Advocate General that expression existing quota appearing Section 95 of the Andhra Pradesh Reorganization Act 2014 should be understood only to mean existing seats as in the date of bifurcation.
Yes.
Yes, ma'am. Lordship may come to para 27 will apply.
What happened to this division bench? Challenge further? No.
Sir, no?
No, this division bench 2016 6 ALT was assailed further before Supreme Court. What happened?
No, my lord, not.
State did not file an
It
appeal.
was not. It was relied upon,
Accepted.
same judgment relied upon the API court also, my lord. That is the next
State
judgment, my lord.
accepted.
Yes, ma'am. Accepted. The last Lordship may see para 31 is the, I will not much trouble, my lord.
Much. No.
Para 30. It's answers
No,
everything.
it's not a trouble. It's a pleasure to hear all of you. We only request to be concise.
Yes, ma'am. The para 31. The above table squarely answers the contentions of learned Advocate General. In other words, what is available to the local candidates in the state of Telangana, MCH, surgical oncology bifurcation the bifurcation.
We have already read it. See, we have read it, marked it also.
So earlier only one seat. After bifurcation, they added 2 seats, but 2 seats also comes under common court. That is the principle laid down by the judgment, the judgment of the Supreme Court. The same judgment, the next judgment, it was the same judgment relied upon by the accepted by the API court also. That is 2022 ALD 658.
Huh? Now, which paragraph, Mr.
Para 18 million. Para 80, 18.
80. Yes.
Although reference made to the Article 371D of the Constitution of India, however, the main focus on the petitioner's arguments revolve around the benefit of accruing them under Section 95 of the 2014 Act. Therefore, the present order will focus on around the core issue. The Section 95 of the 2014 Act, which has already been extracted in the preceding paragraph, categorically provides that Government of Andhra Pradesh and Government of Telangana are mandated to law maintain the existing admission quota in all government or private aided unaided institutions. Higher technical medical education are provided under 371D of the Constitution of India for a period of 10 years, during which existing common admission process shall continue. The expression shall all students in the successor states, the existing common admission process together with the expression, the existing admission quota, and shall continue important and relevant for the adjudication of the issue brought before this court. The deep perusal of the provision of the would make manifest that existing common admission process shall continue as such period of 10 years. The focus on the legislative wisdom of Section 95 of the 2014 Act is continuation of the existing common admission process in relation to the existing admission quota in all government, private, aided, unaided institutions of higher technical medical education. As a result, both states are obligated to, in law, to continue the existing common admission process for a period of 10 years in the field relating to the medical, the next paragraph. It's true that it appears paradoxical that person who is not serving in the state of Andhra Pradesh still treated to be in service candidate in the state. However, as long as the mandate of Section 95 of the 2014 Act is operative, we have no option but to give full effect to the legal provision. The words of the provision as employed in the Section 95 of the 2014 have to be read and give effect as it is. As the court is not entitled to read down the provision, as a matter of fact, there is no such challenge drawn by before this court. Taking in the overview, we are notified the judgment rendered by the Division Bench of High Court of Judicature of Hyderabad for the state of Telangana and state of Andhra Pradesh in the Panindra Nag Kumar Naisetti in India University of Health Sciences. That is earlier judgment I was given. In view of the above discussions, the impugned amended GO MS 150 of dated 11/12/21 restricting the consideration of eligibility of doctors serving in law only the state of Andhra Pradesh is in violation of the section 95 of the 2014 Act. Therefore, we have no hesitation to setting aside the amendment to the extent it restricts the such consideration to the doctors serving only in the state of Andhra Pradesh. Extent the petitioner who are serving in the state of Telangana are also entitled to be considered as in-service local in-service non-local candidates on the respective quota for which they are applied. The consequent upon the setting aside the impugned GO MS number 150 dated 11/12/22 to the extent indicated above. The resultant notification dated so and so issued by identification state so shall also stand set aside the second. The same will be
This decision was not taken note of for this 16. This will
my submission that.
Where?
My respectable submission that the section 95 indicates only quotas, not states. That is my respectable submission. Is squarely covered. That's all.
Thank you.
Yes, my lord, sir. Before I go into the, my lord, I'll just confine to the legal submission, my lord. My lord, sir, as on 2nd June 2014, there were 20 medical colleges, my lords. And the number of seats as available was 2,850. My lord, sir, according to the presidential order as then, my lord, sir, towards 15% of the quotas were 280 seats, my lords, as on 2nd June 2014. In 20 colleges, my lords. As on 2nd June 2014, there were 20 colleges. The total quota towards 15% is 280. My lords, thereafter, in these 20 colleges, 33 seats were increased. 33 seats. My lords, 280 plus 33. 330.
When we are 313 seats.
13.
So when they were increased?
My lords, these are continuous, they are continued to be available.
No, 20 colleges, 313 seats were increased.
33 seats were increased after 2nd June 2014 in these 20 colleges which existed as on 2nd June 2014. What is made available by the state of Telangana is 313 seats as of now also in those 20 colleges are continued. My lord, sir, the total, my lord, sir, from 2019, my lords, on account of need 15% all India quota it is to be reserved. Those seats are 540. My lords, for the purpose of appreciating as to the participation from Andhra region also in the total allotted seat, in the total seats. My lords, the students from Andhra and the rest, Andhra will be competing in total 853 seats, my lords. అంతే ఇక్కడ రాసేట వాళ్ళే.
Jharkhand.
My lord, this.
So what is total? I mean, give us a chart.
Yes, yes. in these 34 colleges, my lords, what has been done, my lords, that there is no reservation in respect of those 15% which was earlier available in 20 colleges, which is now available to them in those 20 colleges still. చెప్తారు.
So let us, I mean, we were aware this, we have seen this. How do you, this thing 540 plus 313 for Andhra Pradesh?
My lords, the 540 is the All India quota in which even the people hailing from Andhra region also can compete. But what is exclusively reserved?
No, anybody can come, right?
Anyone can compete. This
Telangana person can
yes,
also
my lords.
come.
Yes, my lords. All of them.
All India quota.
Yes. This
So
is a chart, my
therefore,
lords.
no. So since you have said 15, so what is like 510 for unreserved quota? Advocate General.
Yes, my lords.
So let us see that 510 for Telangana students and 313.
510, my lords, by this removal of this 15% quota results in 510 seats, my lord, which will be exclusively now will be entitled.
Exclusively.
This 15%. So they will get additional 5%.
So like on basis of limits are different. Maybe seats are reserved to people.
330. 540 unreserved is there. 330. They will be competing in 850.
So 34. 34, they are removing that character 15%. So additionally, 510 seats will actually come with Telangana. That is information. Please continue. 313. 10%. So this 313 remains only in respect of 20 colleges. They will not be exhibited for this. 34 colleges. It would be 34. This is they say that we need to
So what is your submission? Yes,
My
Advocate
submission
General.
is, my lords. My lords, with regard to the citation rendered at the bar, my lord.
No. This, what flows from this figure
My
you
lord,
have
this
given?
chart would show the details as to the colleges which are existed, which were existing on 2nd June 2014 and the colleges which have been established after 2nd June 2014.
34 colleges.
New colleges. My respectful submission, my lords. As far as the presidential order is concerned, the government of Telangana, my lord, stood by the presidential order which is applicable to all the regions in respect of those institutions which were there, my lords, which are still there as on 2nd June 2014. My lords, the purpose and intent of the objective of the State Reorganization Act and to make available the resources as were existing as on 2nd June 2014.
No, one query, of course, what subject to what you argue, we will note down your submission.
My lords.
But based on a domicile, whether reservation can be provided to the extent of 100% excluding anybody else.
My lords, as far as
because that appears to be in contravention of law laid down in Pradeep Jain.
My lords, Pradeep Jain case has no application to the state of Andhra Pradesh for the reason that it enjoins Article 371D. Presidential order is the law. My lords, I'll share the judgments of 2016 to SCC.
So please tell us what are your submissions.
My lords,
Number one.
The Pradeep, the rational, my lords, the ratio laid down in Dr. Pradeep Jain has no application to the state of Andhra Pradesh because of Article 371D. My lord, the Honorable Supreme Court in Sandeep versus Union of India has clarified this. మీకు తెలుసు ఉండాలి.
Sir, so first submission is Pradeep Jain does not apply.
Does not apply. Which is clarified by the Honorable Supreme Court. The last, but one para.
Which para?
My lords.
16 to SCC 328, which para?
Yes, my lords, from 36, my lords, 36, 37 and
We
38.
have referred.
Yes, my lords. At page 360 of internal page, my lords. There are 36. We have referred to the aforesaid judgment in extenso as the Land Council appearing for the petitions have laid immense emphasis that there cannot be any reservation of any kind in respect of postgraduate or super specialty courses regard being had to the law laid down by many judgments of this court. It is urged that the state of Andhra Pradesh and Telangana cannot apply the domicile test only to admit its own students, and that too also in respect of 15% quota made for non-local candidates. We have already analyzed the factual score at the legal position. The undivided state of Andhra Pradesh enjoys a special privilege granted to it under Article 371D of the Constitution in the presidential order. The judgments of the larger bench do not refer to the said article, nor do they refer to the presidential order. But the said issue did not arise in the said cases. A scheme has been laid down in Pradeep Jain. The concept of percentage had undergone certain changes. In Rita Nirankari, the same three-judge bench clarified the position which I have already reproduced herein before. However, in C. Surekha, the court had expressed its view about the amendment of the presidential order regarding being had to pass the passage of time and the advancement of the state of Andhra Pradesh. It has been vehemently urged by Mr. So-and-so that despite 27 years having been elapsed, the situation remained the same. We take note of the said submission and we are also inclined to echo the observation that was made in Fazal Kapoor, wherein it has been held thus. In Pradeep Jain's case, this court has observed that in super specialities, there should really be no reservation. This is so in the general interest of the country and for improving the standard of higher education and thereby improving the quality of available medical services to the people of India. We hope and trust the government of India and the state government shall seriously consider this aspect of the matter without delay, and appropriate guidelines shall be evolved by the Indian Medical Council so as to keep the super specialties in medical education unreserved, open and free. Para 37. The fond hope has remained in the sphere of hope, though there has been a progressive change. The said privilege remains unchanged, as if to compete with eternity. Therefore, we echo the same feeling and reiterate the aspirations of others so that the authorities can objectively assess and approach the situation so that the national interest can become paramount. We do not intend to add anything in this regard.
What was the issue in this case? 16 to
domicile, my lords, domicile. Because, my lords, the state of Andhra Pradesh enjoins the Article 371D. My lords, para 38, my lords, consequently, the writ petition as far as it pertains to the state of Andhra Pradesh and Telangana is dismissed.
So first is Pradeep Jain does not apply. Second submission is?
My lord, second submission. My lords, why, my lord, the statements of objects and reasons of the Reorganization Act is quite relevant. Why the state at all? My lords, in fact, the full bench judgment of this court also, when, my lords, the state of Andhra Pradesh was constituted, was formed, the objects pursuant to which, my lords, pursuant to the demand of these region, the Andhra Pradesh, the presidential order came to be issued on account of backwardness in certain parts of the state. My lords, similarly, when the state of Telangana, the demand for state of Telangana, how it emerged, my lord, the statements of objects and reasons would indicate and throw some light as to why the demand.
No, what we would appreciate if you can tell us whatever submission and then elaborate.
Yes, my lord. My submission is, my lord.
Number one is Pradeep Jain does not apply.
Doesn't apply. My
Number
lord,
two,
the creation of separate state of Telangana itself for the betterment of social, economic, political and other aspirations of the people of that region, which has been a long standing demand.
So,
my lords, various provisions of the Reorganization Act would, my lords, go to show that what
Advocate General, you have heard them saying, first submission is this amendment is contrary to clause 7 of presidential order.
Absolutely no, my lords.
So, second submission is that it is contrary to section 95 of Reorganization Act. Thirdly, even assuming that you have power to prescribe reservation in respect of institution which have come into force after, which have come into existence after bifurcation of creation of the state of Telangana, then also there can't be total exclusion. These are the three submissions.
My lords. My lords, as far as the institutions which existed as on 2nd June 2014.
First is contrary to presidential order.
Absolutely no, my lords. It is absolutely, there is no.
So what is your submission?
There is no breach of the presidential order by the state of Telangana.
No breach of presidential order. Second is
breach of, my lords,
it is not in contravention of section 95.
Absolutely no.
Of section 95 and
in the light of, my lords, in the light of the language
reservation for domicile you can do.
Domicile, my lords, because of the state 371 enjoins, my lords, state can definitely reserve the seats.
All seats.
All seats, 85% seats, my lords.
No, but
that is 85%.
No, 85% is fine. But in respect of institution.
The 85%, my lords, now 15% is the All India quota. The remaining 85% is exclusively reserved for the state of Telangana. That is what the purport of GOMS 73. That they can do in the my lords, I'll read section 95.
Challenge is only in respect of 34 institution if you have put it in terms of figures. That these seats in 34 institutions, they have been altogether excluded.
15% is excluded.
So
these institutions admittedly were established after 2nd June 2014.
Yes.
My lords, what the state was obligated is existing quota. My lords, how it is to be interpreted, section 95, my lords, your lordship may have to interpret in the light of the various other provisions where 2nd June 2014 is the cutoff date for distribution of every, my lord, asset, liabilities, money. Therefore, my lords, whatever existing as on 2nd June 2014, including the educational institutions, my lords, the state of Telangana is bound by the mandate of the law. Accordingly, my lords, as far as the 20 educational institutions, my lord, the judgment which was referred to is concerning a Usmania University College which was existed as on 2nd June 2014. Therefore, what has been rendered in the judgment, my lord, may not have any application to the subject case where after 2nd June 2014, institutions which have been established, the seats available in those institutions, the action of the state in making those seats exclusively available, that is 85%. Convener quota is 85%, 15% for the All India quota, my lords. This is in consonance with the original presidential order and consonance with section 95, my lords.
So, will you give us a figure of these additional number of seats, like 34 colleges?
It is also made available to 15%, my lords.
So, please tell us with reference to number first. So, 34 colleges, how many seats were made available?
34, my lords, this is combined, my lords, in fact, I'll.
No, perhaps what we were wondering, learned Advocate General, that if you can point out that out of, 34 seats, supposing what you are trying to say as we decipher is that out of these seats, X number of seats in 34 institutions which have come into existence after bifurcation of state.
Yes, my lord, 8,215 minus 2,850 is the seats available.
5365 seats increased in 32 colleges.
Yes.
34
Yes.
colleges.
Yes, my lords.
So their case is that in respect of 5365, they are excluded altogether, right?
Yes. Unreserved seats. Yes, my lords. They made now unreserved.
So, no, not this 5365 seats, additional number of seats in 34 colleges are reserved for domicile of this
Telangana.
state.
This is in consonance with the very objective of the presidential order.
Presidential order, Article 371D also says that you can, just loudly thinking.
Yes.
It says that you can create a provision, a special provision for this thing.
Correct.
Right?
Yes, my lord.
But this power to make a special provision, does it include power to exclude somebody altogether?
My lord, this is not an exclusion at all, my lords. Now, my lords, what is the obligation of the state of Telangana is only to ensure that the
This thing is residents of Telangana and not, it doesn't owe anything to
in
Andhra.
respect of, my lord, in respect of the institutions which have come up later in the progression of the development, my lord, which have been established subsequently, there is no, my lord, there cannot be any legitimate demand either from Andhra or the people of Andhra to claim a right in the institutions, in the seats which have been, my lords, which have emerged after 2nd June of 2014. My lords, 95, my lords, if we read 95, my lords, if the lordship's kind permission, I will read. In fact, my lords, Andhra government has taken away everything. The GO which I will read to your lordships, my lords, even that 15% has been taken out.
They also issued similar GOs.
At least, my lords, the state of Telangana has maintained in terms of section 95 all those seats available to all the 3 regions.
Yeah, what is this?
That GO government also issued similar GOs.
That is at page
103, UMS number 103 and 104.
At page 46 of this, my lords. The state of Andhra Pradesh is sure the identical GOs, my lords, the court, though it is challenged, I am given to understand, my lords, there was no interim order as such passed in. I am only just apprising your lordships, my lords. I will not rely upon that. 16/7/2020 at page 46. The entire process of, my lords, counseling is complete. The seats were all allotted in the state of Andhra Pradesh. Page 46. My lords, amendments which have been carried out by the state of Andhra Pradesh on page 47, my lords. From amendments, my lords, in the said rule, in rule 9(1), under the heading region-wise reservation of seats. Para 1, my lords. By item A, the following shall be substituted, namely, admission to 85% of the seats in each course in non-statewide institution shall be reserved for the local candidates, and the remaining 15% shall be unreserved as specified in the Andhra Pradesh Educational Institutions Order 1974 as subsequently amended in colleges established prior to 2nd June 2014.
So, Mr. Advocate General, this requires consideration. We are convinced, but the thing is, one thing via media on the interim relief, because all admissions declaration is withheld, right? Results. So, why don't you consider their case also suggestion, right? Subject to what you say, and find out where they fit in and give us in seal cover.
My lords, the obligation of the state, my lord, that will, your lordship's suggestion will certainly be discussed.
No, for another via media is that urgency is that the results, you should be allowed to declare the results of all the candidates, right?
Confining to the petitions.
Huh?
As far as the petitioners are concerned.
No, the whole thing is put on hold, right? That is the urgency.
Correct, my lord. My lord.
That's why you said 10:30, that whole thing is for big, because we are getting delayed and the whole process is time bound thing, Briduldhar. So this thing, it has to be concluded before 30th August, right?
My lord.
30th. Then so therefore what happens, like in the previous case, we are just contemplating that this requires consideration, right? You will not be able to, they will also seek time. 30th September. So how can you protect the interest of these petitioners pending adjudication of this issue? You please tell. No, that's on merits.
And the allotments were also made below, excluding the candidates from Telangana. But they confined only seats below to local areas below. Andhra University, first phase of counseling is over. But excluded. This is an additional benefit to the writ petitioners. They had extra benefit of seats.
No, Mr. We are only this thing. We are saying that a arguable case is made out. He is also argued. So therefore, we don't. Supposing if we vacate the interim order and say after some time petitioners succeed in the writ petition, what happens?
Your lordships confines to only writ petitioners who will convey to the Milord by chance. Only
Confined to what?
The order, interim order confined to the.
Of course. Correct. We can clarify this. It is confined only to petitioners.
And subject to the outcome of the, my lords, your lordship may modify so that they can.
And it can't be accident. No. If somebody is watching and waiting, it will not be done. So how do we, yes, please tell us,
My lord, sir.
Advocate General.
My lord, sir,
It's not that we will record your concession, but how do we protect the interest of these people? Interim order is for what?
Interim order is, my lord, to consider their.
Permitting them to exercise web options.
So what happens now? What is the now this thing? How do their interest is protected? They have indicated web options. Now you have this thing. No. We want to understand. You have withheld the result of MBBS. Whole thing.
Whole thing is stopped.
Options.
When are the classes likely to start?
Classes will takes after second phase of counseling. Classes will commence after second phase.
Sometime tentatively in
Tentatively will have October, 1st September.
First
September.
Oh, Mr. Advocate General, one thing, like since you have given us statistics, so dispute is only in respect of these additional seats.
Yes, sir. Yes.
Rest everything you can proceed.
Yes, my lords.
Why are you withholding the this thing result of everything else?
My lords, if your lord, my lord, some clarification is needed. Therefore, if your lordships clarifies that, my lords, that will we'll go ahead with this.
What we are thinking is, so far as the 20 colleges is concerned, you go by your percentage.
Yes, yes.
Now, so far as 34 colleges is concerned, where do the petitioners, by applying the same procedure which is applicable to 20, that you will apply and give us the list on Monday in a sealed cover?
Seat matrix have to change. Seat matrix has been prepared in accordance with GMS number 72.
I know their options would be there, no, based on their options, where do they fit in? You are not allowed options of.
Unless the seat matrix is altered, me opting for their existing unreserved category seat in that college does not arise.
Mr. One thing is that you don't know if you're we don't know if you're such a meritorious student. You may get in 20 seats
colleges.
also, 20 colleges also. Who knows? That's why that's the purpose. So that we need not examine if you get into in 20 colleges. Then where is the question of challenging of remaining 34?
Yes.
This is all in anticipation that you will not this thing qualify for 20 seats, 20 colleges.
It needs some changes in software, Milord.
That the entire process would require altercation in the software per se.
Software, it needs some changes in software.
Unless the software is altered, the proposition of verifying my position would not arise.
Their cases will be considered without in existing colleges, 20 colleges, and then they report back to the lordships on Monday. If anyone succeeds in the 20 colleges, those repetitions becomes infectious.
Correct. That's
Yes.
what.
Yes.
No, but you announce the result.
Now we will announce.
Yes. Why for 8 petitioners or whatever 20 before us, you are depriving so many candidates?
Yes.
Like I mean, their anxiety level is increasing every day.
That will solve the present issue.
One thing, Mr. Just we are all exploring all options, right? At this stage, thinking aloud. It's all like subject to this thing. One option can be like the interim order can contain two stipulations. Number one is their candidature shall be considered against the vacancies in 20 colleges to which they are entitled. There's no dispute.
Yes, madam.
And supposing if these students get admitted in vacancies in 20 colleges, right? To that extent, their petition challenge is rendered academic. Second option is that second option could be that you give us their entitlement against the vacancy position in 34 colleges in sealed cover.
Yes.
On Monday, declare the result, everything.
Yes.
And give their entitlement to us in the sealed cover against third. If they don't make it in 20,
yes,
then their entitlement will your software permit this exercise? That's what you have to examine. Third is option is thinking aloud. You go ahead as per your software, but while giving like a declaration of the result, you will consider local candidates entitlement, right? Belonging to state of Telangana. You will consider their this thing. So against you will know where they stand. So in order of merit, supposing the person, the petitioner is at item, say serial number 31. And person next below him is a candidate belonging to Telangana who is available to be who is eligible to be admitted under your rule. You give admission to him or whatever, declare his result subject to outcome of this WP.
Yes, yes, sir. Yes, sir.
This will contain this thing that you will do, that you will indicate that your admission which is being offered is subject to result of this WP.
Yes. This last me please to observe, my lord, will communicate.
Right, so their interest will also be protected.
Yes.
And we try to decide it as early as possible.
Yes. Lordship, I kindly modify that.
Your interest is protected, right?
Technically, usually there's a challenge to the rule.
No.
If the rule is struck down, usually those orders should operate in them. That's my humble submission. It's subject to what your lordship may say.
No. See, Mr. Rule is struck down is fine.
Later, if your lordship struck.
No, Mr. See, it is not possible that we continue sitting tomorrow till 2 o'clock and thereafter till Monday we dictate the order. Understand why this is? Because the way he began, we tried to, and he argued also to all of you, but advocate this like 4:20, when he will go on for another this thing, you will rejoin. Then there has to be time to deliver judgment also, right? Everybody is, but Mr. Rao, you could have done it. I mean, we are surprised that at least in respect of all 20 colleges, you could have. Why are you holding the process for everything?
Lordship, asked them to exercise their powers.
Which option? No, but Mr. Advocate General and Mr. Rao, whether what sort of this thing, what can you do as per your software?
It will be combined only with 20 colleges. Because SEEK matrix is so prepared in accordance with GOM 72. Where they will be considered in 20 colleges, Lord. And we will report back to Lordships on Monday.
And you will declare the result?
Yes, Lord.
Yes.
So that other students will take admission. Other meritorious students.
Yes.
Yes.
They are not fighting against them. No, everything is put on hold against the persons whom.
Even meritorious than the petitioners who are non-local,
Well, unresolved category, they will get admission.
They may be getting, yes.
Yes.
Their admission is also start.
The issue remains unresolved, your lordships. The point is, if the result,
Issue, according to you, it should be pronounced right away till
I am not insisting.
11 o'clock,
Your
judgment
lordship,
should be pronounced, petition should be allowed.
not at all on that, your lordship.
Is that what result?
If the result
We are
is
on the,
declared,
Mr. We are on the workability of interim arrangement. You give constructive suggestion to that, it is understandable. You are saying that validity of rule has not been decided today. That's correct. Issue remains unresolved. Nobody is saying.
the option that is suggested, your lordships, is not via media, is what my submission is.
So that's what you say. We are only, you are speaking about interim arrangement. Now what can you do? What can you, how? So tell us.
Some of the ideas which.
Ideas we said.
Please, what are your suggestions?
My submission would be on the idea part.
1 minute. We told that we are doing loud thinking.
Yes, sure.
Please say that this could be possible solution to this.
The only point would be that
to admit them.
Not at all, your lordship. Not at all, your lordship. If I am permitted to opt, or my candidature is considered for the remaining 32 colleges also, that is when the via media would arise. Me being considered for the remaining 32 colleges cannot be worked because of the software predicament. That is where the via media is not being possible. This is what I wanted.
No. Mr. One thing,
lordships.
Another aspect which we can point out
lordships.
Is that rule exists. It has not been struck down.
Yes, sir.
By way of an interim measure, we grant a relief which is contrary to the rules. Can this court do? Any court for that matter? Can it grant what you are saying is amounts to granting the interim order in violation of a statutory provision which has not been struck down and which is not being decided today.
My humble submission. The interim order that is already granted in my favor is also not protecting my interest, considering because of the predicament of the software. Therefore, your lordships.
So you tell us what is the justification? No, just a minute. What is the justification? 32 people from Andhra came and they hold everybody on ransom. What these poor students have done? Why their result should not be? That's only because of this software problem. You will understand. Everybody is hold everything on hold. Is it this possible? Can't be.
My only.
Can't be. Your interest, we will protect by directing addition of seats. We have that power. Supreme Court has said, in the event of success, court can direct creation of posts for these people.
My lords.
But alternatively,
we gave an undertaking not to declare the result. We should not have done. Even this section published when they are contesting in one of the Can you not this thing?
Software permutations, like as we were discussing, 20 colleges is 34 colleges. Where do they fit in and give it to us separately?
First we will release list of 20 colleges. Then thereafter we will direct.
No. So that you tell us whether your software.
No, this is.
It is ultimately software.
Yes, correct. So we can permit you to declare the result in respect of 20 colleges.
Yes, sir.
Then what happens to 34?
34, we will convey to your lordships after the allotments are issued. We will convey about the places where they fit in subsequently.
No, but you declare.
Now it is not possible to alter the seat matrix at a once. But first we will release below 20.
Altogether,
With your lordship's permission.
1 minute, one. So, so you will declare results of this thing, 20 colleges.
Yes, sir.
Including consideration of these people.
Yes, sir.
So we find out what has happened.
Yes, sir.
Right.
By Monday we will report back.
And then what happens to our, this thing is anxiety is, what happens to remaining 34 colleges?
We will consider, my lord, after giving report to your lordships, we will consider, my lord, on Tuesday or Wednesday and report back to your lordships. Whether they are fitting, my lord, those 34 colleges or not. Because
that you can do
the rule is there, my lord. Software is so, we are prepared as per the rule. My lord, we will first declare, my lord, as an existing.
But this you could have done, right? Why did you this thing give an undertaking that we will not
because
declare?
Lords may kindly see.
20 colleges you could have.
Because we are not included.
We quite see this point that there's no point in withholding results of 20 colleges.
Yes,
they have to this
yes,
thing.
Lords may kindly permit, my lord.
And what happens to this thing? Additional this thing, 34 colleges also.
34 colleges will be again, we have to change the software, reserving in those colleges 15% unreserved seats. Then we will run with these petitioners and report back to the lordships.
No. The dispute here is again one thing, Mr. Prabhakar. Dispute in respect of 32 colleges. 34 colleges, sorry.
Yes,
34 colleges is in respect of 15%
unreserved seat. Unreserved seat.
15% unreserved.
Yes, sir.
So why don't you declare results in respect of 34 colleges in respect of other quota, which is not challenged? 85%.
That may not be possible. We will consider 84%. We will consider.
No. We are suggesting to you, we are trying to understand that see, in 34 medical colleges, the dispute is pertaining to how, what is the percentage of seats? Number of seats, Mr. Advocate General. 5365.
510.
5365. But total number of seats in these colleges are 5,000. No, but the dispute is not 5365 in this petition.
Lords may kindly permit us to declare results confining unreserved seat 20 colleges and report back to our lordships on Monday. Next day we will run the software by altering it. 50% will say the results of these candidates. Whether they fit in or not.
This you do at the first instance.
Yes,
but the possible scenario is some of the petitioners may make it to 20 colleges, some of the petitioners may not make it to 20 colleges. They may come into
that's right. You see, we are protecting 20 colleges. If all of your petitioners make it, then there is no issue at all. It becomes academic. We can close this. If they don't make it,
then it survives.
34 colleges, that 15%, how will that they will tell us by Monday about the the software permutations, combinations, how what modification they need to make apply.
TCS handles Mullet subject to what the council may say. TCS
That he
handles
will do,
pure
right?
technical. We
Arey,
will not-
See, software is something which is a code which is a man
We are
written.
not getting into.
So you can alter anything.
We are amazed by lighter weight. We are amazed by your confidence that you will not make it in 20 colleges, right? That you are aware about the performance of petitioners. Huh? Lighter weight we said, Mr. Yes. By not also putting some query. Yes.
You see, ultimately the software,
State has chosen this 11th hour. Yes.
you see, software is man written code. The permutations, combinations can be changed. It's only algorithm which they need to change.
Yes, ma'am.
Correct? In which case, whatever they have done, you see, but for these 34 colleges, earlier 20 colleges, same system was there. Let us say they say instead of 20 colleges, they apply this same software next to this thing for 34 colleges and see where do the petitioners fit in.
Well, this,
Or after that is, after, that's what I'm saying.
From TCS, if he says so,
The Lordship,
then we'll be satisfied. If that is possible or not.
See, in software, nothing is
No.
Nothing is impossible.
No question of even if it is this thing.
Software is something which is directly fallen from the heaven.
Why should everybody on role like this? For your everybody, all other students in Telangana cannot be asked to wait because you have chosen to contest.
Absolutely.
Nothing. This will not permit.
State has chosen this time.
No.
State has brought this amendment to the
This is our conscience doesn't permit. This is absurd something. 20 seats, everything else is on hold. What is this?
But it
How
has
can this be? We will direct this thing if we are not doing so. But he has been more than reasonable in saying that just permit us to declare. You can't object to this. That no, let them not declare for 20 colleges also. This
Nothing. 20 colleges, your Lordship, let them publish.
that's what he's saying. Just
Yes,
you
Your
don't listen to him.
I heard.
Then where is the scope for argument? Mark the presence. Yes, madam. Mark the presence. Which case we should file the order or pass the order? You tell us jointly. Which writ petition, advocate?
Item 80.
18047. 18047.
Your Lordships.
One. It is not necessary because it is coming from respondent. You will always tell something. Supposing if he says item number 83, you will repeat WP number and spare no stone unturned to confuse us. You are here to assist us or what? They are cooperating, right? WP number. Wherever it is item number, whatever, we are writing the number. If it is wrong, then you say WP number 18047/2023. Where is your synopsis? One page you had given, no?
Yes.
In this writ petition. No, the petitioner heard on the question of vacation of ad interim order dated. Where is your this thing, Mr. Synopsis? You don't have a copy?
One
18047 46
18047.
47. The petitioner is a student who has completed 10+2 exam, 10+2 course and has appeared for NEET Which existed prior.
Back to the their fitting.
Huh.
Permit all the colleges.
All right.
For six colleges, six students will have.
Delete. It is further, just a minute, delete. What is have you written? No impediment, delete. It is further submitted by learned Advocate General and Mr. Rao that the They understand.
May I please, your
You
lordship?
will understand that the dispute is only with regard to 6 seats. Who
May I
knows
please, your
what
lordship?
happens? Huh? Ah.
May I
Yes, please publish.
May I please, your lordship?
Let them,
My lord.
this thing declare the result today itself.
Yes, my lord. Yes, my lord.
May I please, your lordship?
We will sign it today itself. Whenever she types first moment.
May I please, your
we will
lordship?
sign it. We are here till it is signed, madam.
May I please,
stop
your lordship?
typing. It seems not before 8 o'clock.
May I,
Madam, do it.
may I please, your lordship?
Nothing, your case is different, right?
Milord, it is item number
Yes, this is the-
37, Milord. Item number 37 in respect of medical
You
admission.
said you did not convince her that she did not feel
Milord,
convinced by your argument.
Milord, there is no interim
I
order.
told you, no, that somebody will stand up to say that. Arey, Mr. Rao, every time you have to repeat the.
Yes.
Ah.
38.
The issue is different, Milord.
That is different. So it will be called on Monday, madam. Monday.
Well, she is not entitled for local candidates.
All right. Argue. We had to go for inauguration of E-Seva Kendra, which is for litigants of this state, right? Litigants who come to the court. That's the only concern. Otherwise, no problem. So then, madam, in most of the cases, there is no interim order. So everything applies to other also. So we should keep on hearing till 8 o'clock and either dismiss or allow. No, but your claim is being contested. We will, madam, we will create one seat for you. Don't worry. On Monday. It doesn't become infructuous.
Item number
Mr. Advocate General, we have power to direct creation of a seat to mold the relief, correct?
Yes, my lord.
If these people succeed, we will,
Yes, my
it
lord.
doesn't become infructuous because it's 5 o'clock today. See, Madam, please appreciate each case we have to take separately. And there are how many cases? 38.
38.
So, same thing, right? We told that that he wants us to sit. Then 2 minutes, madam. Yes, give that. Which item? Then our problem is that once we entertain your application, prayer, we can't refuse others.
Item number 38 also.
38 also.
38 also.
That's what? No. Cap quota doesn't mean that everybody else, all seats in Telangana should not be filled.
My case is different, lords.
No, nothing happens. Madam, do you mean to say that it becomes infructuous? This is your contention? Record? That we will answer that right away. Which case?
37.
37. Learned counsel for the petitioner. Second round of counseling is yet to be notified, madam. This is what we had said on 14/8/2023. It's not over.
Not yet over.
Not yet over. Second round of counseling, you will be entitled to participate. How you are saying?
Eligible may not, or I may not be eligible may not. That's my contention.
We don't know. Your petition may be allowed, may be dismissed. We also don't like may be allowed, maybe this all speculative litigation. No, madam. For one seat, we cannot punish everybody else who is not a party to the court. Got it? It doesn't, we have recorded this submission. That second round of counseling, you say that second round of counseling is scheduled tomorrow and will conclude tomorrow. Then we will hear till 9 o'clock. This is the order which has been passed in your case, madam. Please appreciate. It comes up on Monday, nothing happens. You will still, you have not participated. in the first round of counseling.
Milord, I have already submitted all the.
Remaining cases come on Monday. Tentatively, we will take it up at around 3:30, Mr. Rao. 3 o'clock tentatively, because the list is already like, it is more than 100. So, don't know. So whatever remaining cases, student admission.
Item number 38, Lord.
Up to 48. Huh? 48. So, Mr. In all cases, those who are sitting silently, the order operates that they are permitted to declare the result, right?
Silent.
Right? But she is not silent.
Milord, actually, the petitioner has better chances in the first
You have-
counseling itself. When once seats are.
14 cases.
The seats are over.
What do you say with regard, 1 minute, what do you say with regard to madam's case? How have you filed counter? Ah. Learned counsel for the petitioner submitted item number
37, Milord.
37.
Again, I may be
Learned
permitted to.
counsel for the petitioner submitted that that since the writ petition is not being heard as it's already 5 p.m., 4:55 p.m., an interim order be passed permitting the petitioner to participate in the NEET counseling for academic year 22-23-24. Learned counsel for the university submits that first round of counseling for admission to MBBS course for academic session 23-24 is already over on 4/8/2023 and 6/8/2023, and second round of 6/8/2023.
Ended on 6/8.
Held between 4/8. You sent someone, madam. Why should you take dictation? You have to earlier type the order. 4/8/2023 to 6/8/2023, and the second round of counseling is yet to be notified by the university. In the absence of notification, this paragraph, this court by an ad interim order cannot set the clock back. The fact remains that the petitioner has not participated in the first round of counseling, and second round of counseling is yet to be notified. Therefore, in the absence of notification of the date with regard to second round of counseling at 5 p.m. on 19/8/2023, no relief as sought for by the petitioner can be granted. However, let this writ petition be listed along with other matters for hearing on Monday, 21st August 23.